I have your lordship's gracious leave, my lord, to resume. My lord, may I invite your lordship's attention to Article 25(1) straight away. My lord, these words in Article 25(1), subject to public order, morality, and health, and to the other provisions of this part. My lord, I will deal with the relevance of the phrase to the other provisions of this part in a little while. But, my lord, more important is all persons are equally entitled to freedom of conscience and the right freely to profess, practice, and propagate religion. Well, these words are of some importance because they need to be understood, in my submission, in a very expansive and also in a fundamental manner, so that, my lord, we understand what is the concept of a denomination little later in 26. 25, my lord, in my submission, is the expanse of religious freedom, because this deals with many facets, my lord, of religious freedom. If your lordships will notice, before we come to profession, practice, propagate religion, what is the concept of freedom of religion? We will come to the words practice, profess, and propagate a little later. The first is, my lord, it is the personal journey of an individual towards accepting a philosophy as a religious philosophy. So religion, my lord, has actually more components than what we see in a judgment. Religion has, my lord, broadly speaking, 4 different aspects, and all those are covered in the freedom of religion under 25(1). One, my lord, is the doctrinal or the philosophical content of religion, of a particular faith. The second, my lord, is the practices associated in aid of that philosophy. The third, my lord, is the right of worship. And the fourth is the extent of belief. Now, my lord, in all these 4 areas...
Is it possible to repeat it, please?
My lord, the 4 areas, first is the doctrinal philosophy. The second is the practice of that philosophy. The third is a resultant worship which might arise. And, my lord, the fourth is the evolution of belief. All these 4, my lord, are protected under Article 25(1) just with the word religion. The reason, my lord, why I'm saying this is, it is not possible, my lord, to read all doctrines sometimes in a faith. You read one, but you may not adopt the practices of that doctrine, and you may not actually be involved in external worship either. This is all within the freedom of religion, but this is, my lord, individual freedom. Individuals have this freedom under Article 25. Now, my lord, we come to the word profess. This word profess can mean profess in private. It can also mean profess in public. That is also, my lord, religious freedom. The next word is, my lord, practice. Practice can be in private, and practice, my lord, can be in another setting, which we'll presently come to. And propagate religion, my lord, if that person has enough scholarship and knowledge and he wants to share his understanding of faith or religion, then in that case, he can certainly, my lord, he can give a lecture, he can give a talk, he has that freedom too, under 25(1). But all these, my lord, are subject to public order, morality, and health, and to the other provisions of this part. The other provisions of this part, because when you exercise in this individual sphere, you must be mindful of the rights of all others who are entitled to exercise, my lord, the same freedom. That is why you have this expression, subject to the other provisions of this part. Now, my lord, in this sense, 25.1 is a very big foundational right. And my lord, I'm going to request your lordships to look at conscience separately from the right of religion. Conscience, my lord, can mean a slightly more detached faculty from, my lord, the faculty of religion to absorb religious philosophy and truths. Now, my lord, if we appreciate that each religion, and my lord, this is applicable to all religions, that they have a philosophy, they have tenets, and they have practice to achieve and to implement and arrive at those tenets. And my lord, the extent is also left to an individual depending upon the tenets of that faith. So, my lord, under Article 25.1, these words, my lord, need to be given a very wide and expansive meaning, because there is an exercise of individual autonomy, even in matters of choice of religion and extent of practice of religion. No two people, my lord, may practice the faith the same way, although they may belong to the same religion. But both individuals have complete freedom to practice the faith, practice the religion as they see fit. That autonomy, my lord, is also protected under 25. That, my lord, is different from freedom of conscience. So the freedom of religion, my lord, carries with it not only the right to affirmatively and actively engage in religion, but also establish boundaries within oneself about the extent to which the person would be willing to go and exercise his right. Lord, to this extent, in the area of individuality, it deals with the inner dignity of the person and is therefore, my lord, a very precious freedom which should be given the widest possible meaning. Now, my lord, we come to practice and propagate religion. Here, as a part of faith, as a part of religion, a person may visit an institutional setting. He may have access to an institutional setting. That institutional setting, my lord, is actually 26 of the Constitution. So the denomination, my lord, is where collectively you come together and you express your worship, your faith. All this, my lord, is within the freedom of 26. So in 26, an important point Justice Sundaresh asked, what do the members of a religious denomination do when they arrive at an institution? They exercise, my lord, the rights under 25.1, but collectively, they have the freedoms under 26. So the freedom under 26 is also not entirely, my lord, divorced, if I may say so, from the rights which are actually exercised by members of denomination, because inside the institution, they exercise 25.1 rights. But when they are in 26, and this is, my lord, to deal with a very important question raised by my Lord Justice Bagchi, suppose there is a proponent and there is an opponent, even inside a denomination. My Lord, a denomination also has the freedom under 26 to have internal discussions and debates. That is also a freedom of the denomination. It is not that, my Lord, denomination means simply positions of conclusive nature taken by members of a denomination. There can be discussions, there can be debates, and there can be consensus in denominations too. That is also inherent, my Lord, in 26. That does not have to be located, my Lord, in 19(1)(a). It can be located in 26. So, my Lord, although there is an institutional setting, but as observed by Chief Justice Mukherjee, that all corporations and institutions function through individuals. So when you are in a denomination, it is open to you to express your views within the discipline and decency of that denomination. That also, my Lord, is a freedom which should be ceded under 26. So, my Lord, the freedom to navigate in matters of religion is a matter of personal freedom under 25(1). But when you adopt a creed, when you adopt a philosophy, and if you are an adherent to a particular philosophy, then, my Lord, you come under 26(b). Then you cannot actually attempt to change the doctrine of that philosophy while entering as a member of a denomination. That is not expected because you're an adherent of the denomination. That is why under 25(2)(b), the expression, my Lord, all classes and sections of Hindus not only refers to excluded classes or members of castes, but also includes denominations. That is, access to the temple should be open to people of all denominations. So, my Lord, if you read it that way, you will find that there is an organic movement between 25(1), 25(2)(b), and 26. So, my Lord, 26 cannot actually have what is called a sui generis existence without walking through the gate of 25 and an intention to, my Lord, form an organization in aid of practice and propagation. Now, my Lord, yesterday I mentioned that the word denomination is not necessarily a subset. I said the entire faith is comprehended. But, my Lord, when I say that, even subsects are comprehended. When I say the whole faith is in a denomination, then, my Lord, even those who are sections are also, my Lord, identifiable under 26(b). So, my Lord, cases like Shiru Math, cases like the Shivachar, all these cases will, my Lord, come under sections. And they would also get the same ability to assert rights under Article 26. My Lord, what is significant in the debates is it is clear that the framers were aware of the administration of endowments. They refer to it, my Lord. It is also clear that they wanted Article 25 to be an article of a universe, giving absolute maximum freedom, subject, my Lord, to public order, morality, and the rights of others. My Lord, no individual right can be exercised in violation of the rights of others, because all have identical freedoms. At the same time, in order to see that the right of practice and propagation, my Lord, how do you propagate? For that, you need a denomination. And that denomination must have the ability to acquire and hold property. And it must also be able to establish and maintain an institution. My Lord, Article 26 is not simply about management, my Lord. The concept of management, maintaining and establishing an institution, and also, my Lord, regulating affairs in matters of religion can touch upon religious matters under 26B. And I'm urging your lordships to take a view that nothing, my Lord, is non-justiciable. The only area of non-justiciability is, my Lord, a devotee's faith in a certain philosophy or towards a certain deity. That, my Lord, is something which is completely different, my Lord, from a secular scrutiny of infringement of these rights. So if we stay within, my Lord, the constitutional boundaries of 25 and 26, I submit, my Lord, that your lordships are not precluded in any way by any manner to inquire and determine what is the religion, what are its basic tenets, and how is this religious faith being asserted. So, my Lord, I submit all these cases, my Lord, judges have been able to acquire a certain knowledge about the fundamental tenets of faith. And when I say faith here, my Lord, I mean religion. Because the faith of the worshipper, which is a private matter between him and his maker, is not the area where the court interferes. And that is why, my Lord, I want to say that is an area which is so totally personal to a worshipper, that is not the area where judges interfere. But up to that point, the fact that he has access to a religious freedom in a temple or in any other form, Lord, a church or a mosque, somebody who professes that faith, is an underlying theme, because that is how you will make religious freedom through community feeling possible under 26.
Mr. Subramaniam,
Yes.
as you rightly said, that 26, as there is also a scope for deliberation, discussion, a healthy exchange of view between those following that denomination, and that's very nicely expressed in the Vade Vade Jayate Tattvabodha. This is the scope, so where we can certainly put our, what you can say, the views, have a discussion. So that scope is there.
Certainly. And that, my Lord, has to be located in 26. Because we are not looking at, my Lord, shall we say, inert denominations. We are looking at people who would have views. And, my Lord, this is a process of interaction. My Lord, when we are looking for even a transcendental interaction, in that process, you are likely to have human interactions. And sometimes they can be collective worship, as Justice Sundaresh said. They could be people who are going together to offer worship.
So, Mr. Subramaniam, since you are positing the intra-debate in a denomination in 26B instead of, let us say, 25.1 or 19.1A as I proposed, you would put this in the word manage. Manage will include internal dialectics.
Correct, my Lord.
We have to interpret the word manage.
Yes, you have to locate it.
Locate the word in manage.
Yes.
Manage affairs means debate over the affairs themselves.
Yes. And it is perfectly, my Lord, plausible. It is perfectly consistent. And, my Lord, such debates have taken place. The point is, my Lord, debates have taken place. We have, my Lord, so many schools of philosophy, as your lordships know, in one faith. You have Nyaya. Nyaya contemplates debate in the very nature of things. In one, logic is supreme. In one, experience is supreme. My Lord, there are different schools. And that is why, my Lord, as I said yesterday, my Lord, the limited picture which we are getting from these judgments about certain temples where certain agamas had to be followed does not actually give you a complete picture Because when we deal with this fundamental right under 25(1) and 26, we must know all these four aspects, they exist. The religious doctrine, then, my lord, the practice of that doctrine, and, my lord, if it needs any external manifestation. I'll give your lordships an example. My lord, in the Hindu tradition, there are worshippers who follow Vedic Shastras and do not follow Agamas. They follow only Vedic Shastras. They only use Vedic mantras as their basis. They do not, my lord, go to the Agama Khanda at all. My lord, that is one pathway. There are others. And, my lord, this evolution of temples was also a very forward-looking way by which people could come together and have fellow feeling, as, my lord, fellow feeling of connectedness with members of a community. My lord, this is extremely important. Yes.
Intra-religious fraternity.
Yes. And, my lord, these are all ways. And, my lord, ultimately the meaning of the word religion, I'll show your lordships some treatises which deal with etymology of religion. My lord, the word religion itself means to bond. The true meaning of the word religion in etymology, my lord, there are two definitions. One is given by Cicero.
Isn't it experience, spiritual experience?
Lord, I'm a little hesitant to use the word spiritual experience because, again, my lord, it is within the inner realm of experience. Inner realm of experience. So, my lord, if someone were to read a book, my lord, that's a book called The Eternal Companion by Swami Prabhavananda, which was on the life of the first disciple of Sri Ramakrishna, Rakhal Maharaj. That is, my lord, a case of pure religious experience. That is a case of spiritual, inner experience. We don't bring this, my lord, here because it is treated as guaranteed as a part of the journey under 25. So we don't, my lord, call it out specifically because it varies, my lord. It is so subjective. It varies from person to person.
So once a secular activity, the boundaries of a secular activity associated with a religious practice is identified, all other things are religious.
My lord, all other things are religious, but I will tell you, my lord, where this essential religious practice may be of relevance. I'm trying to say something, my lord, very cautiously. All your lordship's judgments are not, my lord, they have not been written, they've been written with reflection. Well, we must assume so. And therefore, the evolution of essential religious practice is in the context of dealing with claims based on religion, which may not belong to religion at all, but are being masked, but are being clothed with as being religious under the mask of religion. Your lordships must have a tool by which you are able to deal with it. That is why in two of the judgments, your lordships employed a test, which is also correct, because, my lord, you cannot have just one line test. There are multiple factors. You can use the test of an obligatory act. Then it becomes central to religion. I'm giving your lordships an example from decided cases. Chief Justice Das's judgment in Hanif Qureshi's case, where he referred to a certain act not being obligatory. Justice Rohinton Nariman's judgment, where he said that a certain act is not treated as an act commendable, exalted by scripture, and therefore it cannot be treated as something integral. So, my lord, the words integral and essential need not cause, if I may say so, any kind of turbulence or enturbulation as far as dealing with the questions are concerned. Your lordships have very firm terra firma to deal with this question. And, my lord, the only point where I see, and I support all my colleagues, is in the matter of the extent of personal faith and experience which a person, an individual worshipper has. Well, that is not the area of inquiry. So when, my lord, you have judgments which use the words Sometimes you have to find the followers of the faith about the faith. It is a means of inquiry. It is not, my lord, to pronounce upon the faith. It is only to ascertain information relating to the tenets of that particular belief. If you view it this way, my lord, it will be clear that there is cohesion in most of the judgments. But there are two important points. One is the only reason why Justice Mukherjee upheld, my lord, the Hindu Religious and Charitable Endowments Act was based upon a fundamental principle in Hindu law that the donor's foundation and his benediction and his dedication must be truly honored. That is, all that which comes out of that property must be plowed back. So, my lord, it was really an evolution of the doctrine of trust. And, my lord, when they found that the traditional laws dealing with administration of trusts was insufficient, that is, my lord, breach of fiduciary duties by a trustee, and, my lord, section 92, notwithstanding the fact, my lord, it was there in its earlier incarnation in the Code of Civil Procedure, that it was still insufficient to address the need for the deity to whom a dedication has been made, and that a Shabayat must have honestly, in aid of an endowment, became lot principles which sustained this law. But if under the guise of regulation, what was being attempted was actually the management of the temple,
Yes.
then, my lord, it is completely unconstitutional. So, my lord, while the Madras High Court in Shirur Bhatt struck down all the provisions, and, my lord, there's something interesting in the judgment of Justice Mukherjee. He notices a very special section, section 92, my lord, of the 1951 Act, which later became 107, I think, of the 59 Act, which clearly says that no power which will be exercised will interfere with the rights which are granted to denominations under Article 26 of the Constitution. So, my lord, this is the peaceful coexistence. And when he found that it trespassed on 25(1), or it denuded at 25(1) and could not be justified, even with reference to 26B, he struck down all those provisions. So, my lord, I submit with the utmost respect that if we give complete respect to the content of these expressions under Article 25 and 26, my lord, I think that there will be absolutely no difficulty. My lord, I just want to show your lordships just a couple of examples.
There is no need to go into this test of essential religious practice.
My lord,
Because an impression has been created that it is only essential religious practice that has to be protected and nothing else.
my lord, this is, if I may say so, if the judgments suggest, and I, my lord, personally do not think they go that far as to suggest, that if it is not an essential religious practice, it degenerates into a non-religious practice or will become a practice which is capable of regulation. I do not think, my lord, any judgment goes this far. But I would submit, if essential religious practice is intended in aid of discovering the true components of that particular religion, then, my lord, it is assistive in character.
Yes.
That is all. And that can be done, my lord, by courts. Please feel, my lord, your lordships can deal with any branch of law to discover something, my lord, which is as sublime as religion is not very difficult at all.
The court cannot sit in judgment as to what is an essential religious practice.
My lord, if I may say,
A controversy in Sabarimala arises out of that.
my lord, let me
Whether
deal.
the court can discover or distill and sit in judgment.
My lord, this is, let me deal with it this way, my lord.
We will put it this way.
Yes.
The concept of essential practice, as you rightly said, actually, if it exists, it will inure to the benefit of either a religious denomination or a person or a group of persons seeking right under 25(1). Right? So, when it comes to judicial review, 25(2)(b) says on a given, on three contingencies, it can be exercised over a religious practice. That is why the distinction between 20 and 25, 2A and B. So,
Because of the word religious practice.
religious practice, there's no difficulty. But then as we're trying to say is, as we understand your argument is, you can still go into it to satisfy yourself by the court on the existence of essential practice, primarily from the point of view of the practitioner or the person who is having belief, so as to exercise your power, the power of judicial review, in which case you have to be a little bit more circumspect. Okay, when what is required by the court, and see, the challenge will be only when a law is being created, or if it is not there in the vacuum, that will come only on two occasions. 1A, when is it merely associated, any other practice, secular practice associated. To that extent, we can do, whether there is no need for essentiality. Because we have to see the religious practice is there or not. If it is there, then it will go away. Then the next one will be 25(2)B. It deals with the religious practice. There the power can be exercised by the state. In that, the court can go into it, and to caution itself vis-a-vis the existence of a social reform or social welfare. To that extent.
No, let me, I'm very
Yes,
grateful.
just put it, if it is got some touch there, from the point of view of protecting the right given in 25(1).
My lord, I,
Whether it should act as a
Yes.
restriction,
Restriction,
or
limitation.
it is only a supporting or an aiding tool for protection.
my lord, may I now read both 25(2)A and 26 with you again, my lord, because I think they are very, very, very paramount questions. Please now read with me, my lord, 25(2). Nothing in this article shall affect the operation of any existing law or prevent the state from making any law regulating or restricting any economic, financial, political, or other secular activity which may be associated with religious practice. So, my lord, this is a case of a clear boundary between a secular practice and, my lord, a religious practice. They are being juxtaposed, my lord, against each other. This does not cause very much of a challenge, if I may say so. But here, my lord, you may suddenly see that the religious practice which is being invaded is somewhat essential to that faith. Can be. Then you don't have to worry about it, my lord, because it is still a religious practice. It is clearly distinguishable. But let us now come, my lord, to B. B is providing for social welfare and reform, all the throwing open of Hindu religious institutions of a public character to all classes and sections of Hindus. My lord, we will use disjunctive, this clause. Let us look at the first one. Providing for social welfare and reform. In social welfare and reform, my lord, there are two important considerations. Social welfare and reform must not be a cloak. That is, it should not be a colorable legislation which actually seeks to invade religious freedoms under 26B. Then in that case, my lord, the law is void. If it is a color, if it's a fraud on the constitution, that is one aspect. The second is, your lordships are asking me, suppose there is something called social welfare and reform. Can it touch upon a religious practice? Can it touch upon an essential religious practice? Now, there also, my lord, it is necessary to satisfy the words social welfare and reform objectively. There is an element of scrutiny involved by the court to truly examine whether this is advancing social reform or it is eo nomine under social reform.
Gopal Subramanian, in
Yes.
the case of multiple accepted religion or in the case of accepted practices, what is the juridical basis on which the court can interfere?
Well,
Whether the court can declare one is authoritative over the other in case of a dispute arising within the religious practices, accepted practices within the religion.
my lord, I will, can I answer your lordships in two limbs? Because One is the intra-denominational, shall we say, contest about the nature of a practice. My lord, there are cases. You have the most celebrated case, my lord, the Badagalai Tengalai, that has been going on for centuries. And I still don't know whether it is over. But my lord, I'm giving you an example that there can be contests, but those have to be done.
No, you take it, it's not over.
Yes. All right. So, my lord, in such cases, you will need, my lord, evidence, you will need proof, you will need to track. But, my lord, your lordships asked me a more fundamental question. That is the court devoid of adjudicatory power? The answer is, my lord, the court is not devoid of adjudicatory power. My lord, there is no other place where any legal rights or legal injury can be established except in a court. I know, my lord, those are not the, not exactly the ideal kinds of situations, but
So the courts will sit in the armchair of ascertaining the theology of the practice?
my lord, there will be evidence. And it can, my lord, may I say again, my lord, please do not.
So we take it that 226 and 32 will be barred?
My lord, in
It is
case
only
it
under
is
section
an interdenominational fight which requires evidence, then, my lord, 226 and 32 may be precluded. But if suppose, my lord, there is no dispute at all, we can have cases where there is absolutely no dispute on the fundamentals. Then in that case, a question may plainly arise for determination whether this is void or not void.
Vis-a-vis the state.
Vis-a-vis the state. But, my lord, I have not yet finished with reference to this social welfare and reform. I need to add more. Social welfare and reform, there is one end of the spectrum, which is it should not be used for hollowing out or, shall we say, eviscerating a religion.
Yes.
That, my lord, is no social reform. And for that, the onus is too high for anybody to establish as a state. The second, my lord, is this social welfare and reform can touch upon a religious practice if it affects or if reform is required. If reform is required, it can touch upon that practice. My lord, the exclusion of people in temples was justified with reference to anterior texts. Please understand this. This was all justified with reference to some interpretations. But, my lord, they've said no. They overrode it. And the reason why they overrode it is, again, my lord, one must never forget that both Mitakshara and Dhayabhaga schools of law are actually to move away from all those rigors. My lord, he was the founder of Mitakshara and Jamuna Vahatad. Yes, that is for my lord Dhayabhaga. Now, both of them, my lord, they were actually progressive thinkers who said we must move away from so-called edicts, which are written in Smritis and some of them, because they said for the purpose of dealing with present reality, for administering this law, we must have a succinct way, like my lord the Sapinda, as your lordship said. These are all principles which have come this way. So, my lord, evolution always happens. So, social reform, consistent with evolution and progress, is not, my lord, an anathema to a religion. But if that religion is substantially being prejudiced, then your lordships have to consider whether it is a direct invasion of 25(1) and also, my lord, 26. Because, my lord, 25(1), when it says nothing in this article, my lord, there are two interpretations possible. One is the extremely learned interpretation which Dr. Dhaban placed, namely, it removes the right and it also removes the limitation. Well, I would say there's nothing in this article is really for the purpose of enabling the state. Well, this is only for the purpose of enabling the state to legislate and to legislate in respect of very restricted matters. So without, well, not these restricted matters, and without it being subject to public order, morality, and health, the essence of religious freedom under 25(1) and 26 is completely preserved.
Mr. Subramaniam, so I would understand you to mean 25(2)(b) is a narrow window of legislative competence vis-a-vis, in accordance with law, qualifying clauses C and D of 26 1B,
Yeah.
26 1C and D, management, property. That is, any general law can
Yes,
interfere with the right of the denomination to hold and manage the property.
yes.
But when it is impacting affairs of religion, the legislative competence is to be posited to 26 2B, that is social reform or social welfare alone.
Correct, my lord.
So general law cannot make an inroad
No,
into it.
no.
This is what you are trying to
Exactly.
make.
So, my lord, sorry.
So from there, my next clarification I seek from you is, what is social reform and social welfare? Will the state be understood to be within its limits if it says that it is enforcing constitutional duties in enforcing a law or in making a law under the ambit of social reform? Because the state has some constitutional duties envisaged under the directive principles of state policy. It has a constitutional duty to enforce fundamental duties of its citizens. So will these qualify social reform legislations?
My lord, let us take a case of, say, superstitions. Or let us take a case of completely practices which are abhorrent to morality, but which have been conducted in a certain place. Well, the legislature can intervene. It can intervene on the grounds of social welfare and reform. So it is not that social welfare and reform, my lord, is very limited. It can be, my lord, actuated by a proper purpose. But however, what I'm submitting is the extent of invasion.
I just wanted a
Sorry.
clarification. With the word is social
Yes,
and directive principles are constitutional visions.
yes.
So will the constitutional vision of the state be a part of social reform legislation?
My lord, this is again a fairly profound question. My lord, if your lordships look at the preamble, in the preamble there is both the coexistence of justice, political, social, economic. So, my lord, I'm not for a moment downplaying the importance of that question. It's a very valid question because my lord, you have to secure to citizens.
Why I am asking
Yes,
this
yes.
question is because we are delving on the question of constitutional morality vis-a-vis public morality.
Yes.
Now, if we're trying to eviscerate the two, differentiate the two, then when it comes to legislative competence of making inroads, should we again make compartments between social reform and constitutional reforms through enforcing visions as envisaged under Part 4 or fundamental duties?
My lord, in one of your lordship's previous interactions, my lord, in these proceedings, your lordship said that constitutional morality could be the conscience of one person, but someone else may have a different standard of morality to judge it. But, my lord, as far as constitutional ideology and assurances are concerned, it is something which is relevant for the state. But, my lord, this freedom, if it has to be preserved as a part of the basic fundamental freedoms which are integral to the basic structure, my lord, this freedom of religion and conscience is inherent. It is a very important freedom. Then I'm afraid, my lord, we have to read the power of legislation very strictly. And it must be able to establish a direct nexus between the need for that reform and the objective sought to be achieved by the legislation to accomplish that reform. Otherwise, my lord, 25(2)(b) will be completely an overarching, shall we say, it will be a silent inroad into religion.
Yes. For example, suppose the Kerala rules, Act and the rules, for example, had said, in the name of social reform, the entry of women between the age of 10 and 50 to the temple is permitted. Is it an invasion? Or it could be said that it is not an essential practice and therefore upheld. What is the extent of invasion then?
My lord, even in that case, your lordships would have to be satisfied and would need to undertake an inquiry into see whether whether the exclusion as a part of ancient tradition or custom or usage was one which did not fundamentally take away the rights of devotees to go to the temple. That's not the test. That is, in other words, if it is a limited category and it is based upon a rational, and it is also a custom and a usage, and it belongs Lord, to a denomination, because Lord, the word denomination I'm interpreting widely. It is in the context of a faith-based denomination, because it's much easier, my Lord. Otherwise, we will not be able to prove multiple castes, multiple communities, and it will be completely. So it's better to make it sound and principled. And I submit with respect, in such a case, if the usage is present, custom is present, it is entitled to respect, my Lord, ipso facto as a part of that tradition. My Lord, customs and usages cannot be thrown away. My Lord, we will take simplest customs before you enter.
The rule has to be struck down.
My Lord, in that case, it would have to be struck down.
So it need not be on the basis of essential religious practice. Merely because of an invasion into a religious practice, it can be struck down.
It can be.
As it is only a cloak
It
or
can
a
be.
color of social reform.
It can, Mulad, it can be. That's why I'm saying,
Yes.
please treat even, there is an element of, Mulad, automatic strict scrutiny when you come to the words in clause B. Because, Mulad, you are passing a law to invade religious freedoms. Therefore, Mulad, it must be a law which passes tests in all senses, Mulad. It is for the true purpose for which it was intended.
Conversely, if such a ban or whatever it is questioned in a court of law, can it be that ban be struck down on the basis that it is not an essential religious practice?
It can be.
Conversely,
It can happen. That is why, my Lord, please don't throw away the idea. My submission is, please do not jettison this concept of essential religious practice. Please don't, because I'll tell you how useful it is. My Lord, when Justice Gajendra Gatkar in the Dargah committee said, and my Lord, he was also a very progressive judge, but he was also, my Lord, one who was profoundly learned. He said, the crucial words are, don't allow anything, my Lord, he used the word superstitious. If suppose he had not used the word superstitious and said, don't allow anything extraneous to come into religious faith, my Lord, it's completely unobjectionable. Because when, my Lord, a religious right is asserted, the court will take care to see that it is, my Lord, a valuable religious right which is asserted. My Lord, it has to be discovered. And therefore, Justice Gajendra Gatkar said, when we have anything which is extraneous, my Lord, he was so careful. The later words have to be read. He said, if suppose such a claim is made under Article 26B, then that claim will have to be very carefully scrutinized. I think, my Lord, there's no objection which one can take to that sentence.
Now, how do you define the social welfare or social reform? The question is only with respect to this. 25(1)(a) says it's subject to public order, morality, health, and subject to the other parts of this part. If you juxtapose that to religious denomination, which is again, as well said, it is nothing but a collection of belief. You can, what is applicable to a person or group of person will applicable to the religious denomination also. That's the reason why you also said 25(2)(b) will applicable. So as my brother Bakshi also said, can the state be, can it be said that state can restrict the right subject to other provision of Part 3 alone? Because 25(1) itself says on subject to two factors. One is public law, morality, and I think other is subject to the other part. To give effect to the mandate of the other provision of Part 3, starting from equality, Article 15 or 91G, can it be said that the power of the state to pass a law is confined to ensure the due compliance of Part 3, other provision of Part 3 alone? Because anything else is not restricted under 25(1)(a). Is it a proper way to look at it?
No, I've understood, my Lord. Let me straighten. I'm very grateful My lord, my submission, but I like to be clear because my purpose is to assist you and to help to draw, my lord, not necessarily bright boundaries, but there has to be clarity and consistency. My lord, my view is that part 3 is not available as a ground for legislation under 25(2)(b. And nor is it available under 25(2)(a). 25(2)(a) and 25(2)(b) occupy territories which may have some, shall we say, idealistic overlap, but the legislation cannot be done with reference to part 3 because, my lord, what happens in 25(2) is it lives both. It enables a legislation, but it also, my lord, removes the subjection to part 3.
All right. Now, a religious practice directly comes in the way of the other provision of part 3. What will the state do?
My lord, it depends, my lord, upon a case to case. Let me give your lordships a small example.
Under which provision, under which provision of law, under which article the state can assume power there?
My lord, that will, if I may say so, my lord, if your lordships don't use the word part 3, but if it is social reform proprio vigore.
Yeah, that is obviously it's, prohibited under 25(1)(a).
Yes.
It's subject to that only.
Yes, yes.
So it is so apparent, state is of the view
Yes.
that either it's public order morality or other provision of part 3
Yes.
is violated by through a religious practice. It is so apparent. Can it pass a law or not? If it passes a law, under which provision it will come?
My lord, if suppose, let us say, I'll give your lordships, my lord, a clear answer. My lord, for the purpose of a law under 25(2), my lord, if a law has to be passed with reference to the opening part of 25, or shall we say opening part of 26, you already have 3 grounds which are available. That is, my lord, the grounds which are public order, morality, and health. There are 3 available grounds. Now, what does actually 25(2) do? In fact, it does is, your lordships are looking at subject to the provisions, other provisions of this part. Subject to the other provisions of this part, my lord, is in the context of protection and equal rights of religion which are granted to others. It is in that context I'm interpreting it. But I'm saying anything, my lord, which comes within, shall I say, the reasonable ken of social reform, my lord, that is social welfare and reform, will pass under 25(2)(b, but it must be established that it is, my lord, an authentic social welfare reform. So I'm saying, so my lord, it might be that a violation of a fundamental right, now I'm going further, violation of a fundamental right may acquire, shall we say, the appellations and attributions of a social evil which needs to be addressed under 25(2)(b, then, my lord, the legislature necessarily has that power. So I'm therefore reading that the power is there as long as you can demonstrate by means of objective assistance that this is a social evil, this is a social welfare, this progressively takes it forward. My lord, this would be a very harmonious way of reading it, because otherwise 26, as I said, my lord, will get unnecessarily impaired.
Because it's better for us to
Yes,
define it.
I
Otherwise,
agree.
why we are telling you is this, we don't want to give the impression of giving too much of power to the state also.
I understand, my
If
lord.
we restrain, if we draw the contours somewhere,
Yes.
like you are also example, you quoted what I have said
Yes.
earlier, Section 6 of the Intersection Act.
Yes.
If you want to bring it under 25(2)(b,
Yes.
it is not only you can't bring it as public welfare and then say the public reform, but necessarily you have to go back. What is the extent? To that you have to go under Article 14, 15 and other provisions also.
My lord,
Because it is subject to that. Because if they come under this, because absolutely it shuts the door for a religious practitioner, because it subject to that only. Your right is subject to that under the Constitution.
my lord, may I just explain the point like Section 6? It's an excellent point and it's a very good example. My lord, Section 6 belongs to the realm of personal law, as your lordships know. Your lordships know the progression in relation to the right of a widow to hold property, first, my lord, under the 1937 Act, and even under the 56 Act, my lord, it was Justice Syed Fazal Ali's judgment in Tulasamma, that is, when he said 14.2 is absolute. It is only then, my lord, the law became firm that they had absolute estate and they could alienate properties. Till that time, my lord, it was not possible. Now, this, my lord, is actually an amendment. But as your lordships rightly are aware, that there can be even discriminations within the realm of personal law. The removal of that discrimination can still be a social welfare reform, which is directly falls within the province of 25(2)(b). So, my lord, for the purpose of removal of discrimination, you don't necessarily have to go back and hearken to 14, although it is a salutary. But, my lord, you can remove it as a part of social welfare.
For example,
Yes.
if a religious denomination believes that a lady who becomes a widow has to commit sati, and therefore sati must be abolished in the context of 25(2)(b, it cannot be considered to be an invasion of a religious practice.
Certainly not.
We are giving these extreme examples. So social reform will prevail there.
Yes, certainly. And, my lord, it's not only the making of a law, as your lordship said, it is also, my lord, the conscience with which that law is implemented over a period of time. My lord, even though we have had laws which were social reform laws, as a matter of accurate, my lord, if one had to do proper sociological studies, it has taken a lot of time for many of them to have been translated as complete realities. So there is a gap, my lord, even between effectuation of a law and the time by which, my lord, society adequately responds to the law and imbibes the law as a value. So therefore, my lord, I would honestly say that under 25(2)(b, social welfare and reform, my lord, are capable of a wide expression, but they must be, my lord, honestly falling as social welfare and reform, and they must not also, my lord, completely eviscerate the right of the denomination under 26. That is the
Be
point.
a harmony. That's what in Venkatramana Devaru,
Yes.
ultimately it is stated. The proportionality.
In fact,
What is invading what?
in
I think
fact,
we
that
can probably, the issue I think stands quite well debated. Part 3 is an embargo on 25(1), the individual devotee's right, that when you exercise that right on 25(1), you have to respect the part 3 also. So far as social welfare or social reforms are concerned, it's a very wide term. State is not a stranger, state is not an alien. State represents the will of the people. And if the people want certain social evils to be reformed, probably that power can be exercised. But it's very difficult for us to lay down any future
I
guidance.
agree.
It will always depend upon a case to case,
Yes.
whether the reform falls within the ambit of 25(2)(b, or it amounts to exceeding the power under the name of reform, introducing something which amounts to infringement of a religious practice protected under 25(1).
And my lord, to be fair to the learned Solicitor General, who do not have the benefit of so many other submissions, he seems to take that position. His position is that there is a separation between religion and the state. Second, there should be minimal state control or incursion when it comes to 26(b). Third, he, my lord, went up to a point, but I have elaborated it, that every denomination means, my lord, it belongs to every faith. Section thereof will deal with all these subsects. And lastly, my lord, on this question of 25(2)(b, that power, my lord, must be available with the state, even though denominational freedom is being given and the right to religious practice is being totally accepted and preserved. So, my lord, with this, I'll be very, very quick and brief. My lord, if I may just give me my. My lord, I have given an additional submission for your lordship's consideration, but on this concept of religion, I wanted to show a few passages, my lord, from the original submission. My lord, this is volume 1.2 in the soft copy.
596.
My lord, it starts at 595. And if I may take your lordship straight away to, my lord, 3 paragraphs, 19, 20, and 21. That's at page 602.
Volume?
19, 20, my lord, volume 1.2, my lord, page 602.
Para 19.
Para 19, my lord. It is submitted that the etymology of the word religion is from the Latin word religare, and the concept itself is difficult to define in such a way as to comprehend. So sorry. Page 602, my lord. My lord, the running and PDF are the same, so fortunately. 602, para 19. Incidentally, my lord, as a digression, the reason why Justice Mukherjee once sentenced that it's not possible to give a rigid description for the word religion is, my lord, largely because he followed also, my lord, the section of philosophy, Bertrand Russell's theory of specifications. So unless you have a completely exhaustive enumeration, you don't say you rigidly define a particular term. So, my lord, that is why those words come in the beginning of the passage. Then the Latin word religare and the concept, Sir Edward Bernard Taylor defines it simply and briefly as being a belief in spiritual beings. According to Goblet Alveolar, religion is a certain method by which man realizes his relation to the superhuman and mysterious powers upon whom he regards himself as dependent. A more comprehensive definition is that given by Jean Rivet. Religion is essentially a principle of life, the feeling of a living relation between the human individual and the powers or power of which the universe is the manifestation. What characterizes each religion is its way of looking upon this relation and its method of applying it. Perhaps one of the better indicative definitions is that of Fraser. By religion, I understand a propitiation or conciliation of powers superior to man, which are believed to direct and control the course of nature and of human life. In more contemporary terms, Professor Thomas Tweed defines religion as religions are confluences of organic, cultural flows that intensify joy and confront suffering by drawing on human and supra-human forces to make homes and cross boundaries. Well, this, I submit, gives you at least a wide array of thought of what actually is religion. But, my lord, it is clear that the religious faith in all these cases, my lord, everybody has taken off from saying this is a Hindu faith. But, my lord, unless you understand what facet of the Hindu faith is that particular temple or that particular agama is dealing with, the picture looks incomplete. It looks that we are only looking at rituals in that case. It is really the philosophy, my lord, which is equally important. And as I said, my lord, we have you have 6 schools of philosophy, but you have any number, shall we say, my lord, of Vedanta, you have got Dvaita, you have got Vishishta Dvaita, and my lord, even in these, if I may say so with respect, the distinctions are more often than not of form, not always of substance. If one has read through, my lord, this particular subject. For instance, my lord, one of the greatest misconceptions is that Adi Shankara was a monist and he believed in Advaita Vedanta. My lord, this is a straightforward statement which your lordships will hear most people say. The reality, my lord, is slightly different. If anybody reads his bhashyas, he says Dvaita does exist. And he says that there has to be sometimes attribution to form. My lord, ideal is the form of Saguna Brahman. That is the concept. So you do need Dvaita, but Dvaita is not the end. There is still one more when only the absolute remains. My lord, that is actually the correct interpretation of Shankara. In fact, my lord, the number of stotras which he has composed is a legion. So therefore, he is not, my lord, only an Advaitan as is normally understood. My lord, in Vishishta Advaita, that is, God alone exists. Although there is a duality, but it is he who has all the attributes. You don't actually claim any partiality or a part of that. That is, my lord, Vishishta Dvaita. Dvaita, my lord, which is mostly in many Vaishnava and other sampradayas, is where you have, my lord, a dual relationship between God and yourself, the devotee. In, my lord, Shiva Siddhanta, that is actually, my lord, extremely, it has got so many dimensions, particularly in the context of realizing Shiva within you. My lord, it is, if I may say so, the
Journey of self-realization.
I beg your lordships.
It's the journey of self-realization.
Self-realization. That's right, my lord. That is why there is a school of thought that it is Shiva alone who is the ultimate silence and who is the creator of time. Now, I'm explaining this because each philosophy is different. Take the case, my lord, of Sri Ramakrishna. I'm giving another example. My lord, in fact, the Gold Park, my lord, had a beautiful collection, History of Indian Culture. And it's, my lord, one of the most fascinating collections.
One of the best libraries on spiritual.
Yes, certainly, my lord, without a manner of doubt. And, my lord, there, in that philosophy, what the propounder of that faith says is, you realize God by whatever ways and means you can. There are any number of it. Now, my lord, this is one. Now, take the case, let me just give your lordships, my lord, a religion like Zoroastrianism. I'm appearing for some of these trustees. I'm just giving your lordship the idea what I meant by those four factors. The four factors are, my lord, they also, the Avestan language was close to a Vedic Sanskrit. They're very ancient, my lord, extremely ancient. And it is also Aupurusheya, that is by way of revelation. That is, my lord, to Zarathustra, yes, he was revealed. And, my lord, that is the basis of that religion. It is monotheistic. And, my lord, they worship fire and they have a set of principles. That is, my lord, one kind of faith. I'm giving you lordships different only for the purpose of understanding that there are some overlaps too, as one will see this religious freedom. Take a third case, my lord. Take the case of Buddhism. My lord, whether it is Theravada, Mahayana, there were substantial differences. But the fundamental philosophy was based upon the fourfold principle that you have to extricate yourself from the human misery, which is only possible when you remove all the senses of want and craving which lie in your mind through the eightfold path, and ultimately you then, my lord, get moksha, or you get nirvana. That is, my lord, that philosophy. Now, my lord, the Jain philosophy had ahimsa. It had, my lord, aparigraha, that is, you should not possess. My lord, they have these tenets for purification, and by purification, they believe in moksha. They also believe in the theory of liberation. My lord, take the case, for instance, my lord, of Christianity. Christianity, my lord, has actually two parts. One is the Old Testament and the second is the New Testament. The Old Testament, my lord, is actually the Jewish sub-books of the Jewish Bible are consolidated together. The New Testament, my lord, consists of the Gospels, which are the direct experiences. That, my lord, is again a faith. It is a dualistic faith where you believe in the personhood of Jesus Christ as representing the Heavenly Father, and that he went on the cross for your redemption. My lord, that's just, I'm giving you an outline. And each one of these religions, my lord, have a philosophy, they have a scripture, they have not only that, my lord, they have a practice, and they also have ways of communicating with each other. So, my lord, the proponent, if I may say so, exists in all faith, in all faiths. And therefore, my lord, the point which Justice Amanullah yesterday asked, that if suppose I want to go and meet my creator, why should anyone come in between me and the creator? He asked the question, my lord, I understand how that question arises. My lord, in Hinduism too, there is meant to be no gap between you and your maker, as a matter of fact. But when you come to the 26th field, and if you enter a temple, then that temple is actually designed in a way that the Holy of the Holies, as Chief Justice Mukherjee says, must be so sacred and must be kept with such sanctity that you're not allowed to enter there. That is not a restriction on worship. You can stand from your vantage point and offer worship. So, however, my lord, the concept of personal belief, that is, you're leading someone in prayer and it is only between you and the Almighty, my lord, that is sacred space. That sacred space, my lord, is not attempted to be invaded. So if suppose, my lord, somebody went on a purely contemplative tradition in Hinduism, it would only be between him and his maker. There would be no one else. So, my lord, there are different traditions. This tradition of worship in a temple is one of the traditions. And, my lord, because this tradition has come up repeatedly in various judgments, it looks slightly daunting, but it is, my lord, really one of the traditions. It is not the sole tradition of the faith. So, my lord, the concept of karuna, again, my lord, is actually common to all faiths. The concept of compassion is common to all faiths. So, my lord, when we talk, therefore, of religious freedom, the constitution makers, my lord, were aware not only of the multiple faiths, they also knew, my lord, what exactly was this faith about and how necessary it was to have that faith. Because after all, as your lordship saw, to face the trials and tribulations of life, you do need skills, but you need faith. And that is why this religious freedom is so special. So, my lord, having said this, may I take your lordship straight away?
Mr. Subramaniam,
Yes.
Mr. Subramaniam, I'm thankful for clarifying that. A lot of things now fall in place. If I've understood you correctly, that there is a connection, direct connection between God and you in Hindu faith. But then when a temple, which is an institution set up by a denomination, if you want to go to a particular temple, then the beliefs of that denomination have to be adhered to. So it is not a restriction on your connection with that deity.
That's right.
And then that will have to be respected.
That's right. That's right.
Because that has been set up by that domination with a particular belief and a set of principles that will come under the protection under 26.
And that is why, my lord, now may I take your lordships to Bijan Mukherjee's lectures, some important portions, because your lordships will find everything falls in place. All that which I have said falls in place, and your lordships will find that there is contiguity. And, my lord, this is necessary to understand. May I invite your lordship's attention to the volume number 4.6, my lord. Please come to printed page 796. Page 4, 796. I'm taking your lordship straight to the
4.6.
volume 4.6. Does your lordship have, my lord, the third paragraph on that page? It is, my lord, 796. Yes.
Which is the page, Mr. Subramaniam?
796, my lord. But as his lordship is getting the page, my lord, there is a very inspiring live sketch on Justice Mukherjee in the AIR 1955 journal. It is, my lord, a very inspiring biographical sketch of his life. Well, there are only two people who got this degree called Saraswati. One was Sir Ashutosh Mukherjee, the other was Bijan Kumar Mukherjee. And, my lord, he was a great worshipper of Shiva.
Yes.
But you're all, my lord, carrying that heritage and inheritance, all of your lordships. My lord, please see the third paragraph on that page. I'm sorry. I'm just waiting for. This is 2, 3. It's on the screen, my lord, but he has a independence. Yes. Hindu religious and charitable acts have been from the earliest time classified under two heads, namely Ishta and Purta. The two words are often conjointly and they are as old as the Rig Veda. The compound word Ishtapurta has been retained in the writings of all Brahminical sages and commentators down to modern days. And although the connotation of these two expressions was extended to some extent in course of time, the fundamental ideas involved in them remained practically the same. By Ishta is meant Vedic sacrifices and the rites and gifts in connection with the same. Purta, on the other hand, means and signifies other pious and charitable acts which are unconnected with any Shrauta or Vedic sacrifice. And my lord, Prannath Saraswati, my learned friend Dr. Dhawan, had placed that page. My lord, this is that same gentleman. He was a predecessor, my lord, of Justice Mukherjee in those lectures. Now, my lord, the next portion I wanted to show to your lordships is at page 800. Now, my lord, after dealing with the subject about Vedic times and absence of idols at that time, my lord, this is because he's tracing when exactly was this established as a tradition, that is, my lord, idol installation and so on. Please see, kindly come to page, my lord, 801, the second paragraph. The strongest argument in support of this view is furnished by the form of worship prevalent in the Vedic age. It was quite different from the modern form of adoration of gods, which is described in the Puranas or Agamas. So, my lord, this was a much later development. The worship detailed in the hymns of Rig Veda consisted of offerings, prayers, and praises in honors of the gods. The offerings were mainly of clarified butter, which were poured on the sacred fire, and so on. My lord, he gives a description. And then thereafter, please come to over the page. Second paragraph. There is also no mention of monastic institutions in the Vedic literature. According to the Vedic Grihya Sutras, which regulated the life of man, there were the institutions of 4 ashramas prescribed for all persons belonging to the twice-born caste. Then thereafter, your lordships will find, well, just out of interest, I'm not trying to persuade your lordships in any way, but he refers to the concept of a Naishtik brahmachari. If you look at that page a little lower, he explains it. Well, that's an ascetic. Then please see over the page, after this, my lord, then he refers to the establishment of the temples, and then there are, my lord, essentials in respect of a temple. He deals with Debata Shabayatship also, my lord, in lecture 5, and he deals with religious institutions or mutts in lectures 8 and 9. And this is how, my lord, he also then deals with this distinction between private and public trust, my lord, in the light of your lordship's question 1202.
Page 1202.
Yes.
The word used is of a public character.
Yes.
You want to public character means straight away public, and private, or there can be a private trust with a public character also?
Yes, yes, it can be. That is exactly why I'm reading this passage. Because in the context of denomination, your lordships asked me a very searching question. And please see this. Section 92 applies only when the religious or charitable trust is for a public purpose. As Justice Mitter observed in Nobi Shirazi versus Province of Bengal, the essential distinction between a public and a private trust is that in the former, the beneficiaries are definite and ascertained individuals, or who within a definite time can be definitely ascertained. But in the latter, the beneficial interest must be vested in an uncertain and fluctuating body of persons, either the public at large or some considerable portion of it answering a particular description. The fact that the uncertain and fluctuating body of persons is a section of the public following a particular religious faith, or is only a sect of persons of a certain religious persuasion, would not make any difference in the matter and would not make the trust a private trust. So, my Lord, this is the test. So really, the correct answer to my Lord Justice Sundaresh's question is, if it is for a section of the public, and the public, other members of the public can also visit and pay obeisance at the temple, it is then, my Lord, it fulfills the criteria subject to organization. It fulfills the criteria of denomination under Article 26 and also falls within Article 25(2)(b), namely, my Lord, a Hindu public institution for religious worship. I'll give them the note, but I'm going to deal with the questions. My Lord, I have laid out my submissions in that note. I want your lordships just to make two notes because I don't want to take up, my Lord, more time than is necessary. In my note, my Lord, there is a section which your lordships will notice. If I may just give me my note. In my note, my Lord, I have referred to the preface of Rabindranath Tagore, my Lord, in the first volume in the History of Culture. Your lordships will find that at page 58, my Lord. 59 is the actual 61. This is, my Lord, this is the preface of Rabindranath Tagore to the first volume. This was published, my Lord, in 1938.
This is volume 1.
Yes, my Lord, the additional volume, which your lordships have. There's an additional volume, the aid memoir. Of course, it hardly looks like the size of an aid memoir. It's running page 61.
Page, Mr. Gopal Swami?
Yes, this is this one, my Lord. This
Page number?
61.
Yes, this is where.
So, my Lord, this is Tagore's preface. And, my Lord, it is a very beautiful preface because he has quoted, my Lord, one of the verses from Shvetashvatara Parita Upanishad, where, my Lord, the importance is the principle of equalization, which is stressed in all these Upanishads. Your Lordship has 61, my Lord Justice. My Lord, this is their new submission. Can you check whether his Lordship has? And my Lord, this is what Tagore writes. I love India not because I cultivate the idolatry of geography, not because I've had the chance to be born in her soil, but because she had saved through tumultuous ages the living words that have issued from the illuminated consciousness of her great sons, Satyam, Jnanam, Anantam, Brahma. And my Lord, Brahma is truth, Brahma is wisdom, Brahma is infinite. Shantam Shivam Advaitam. Peace is in Brahma, goodness is in Brahma, and the unity of all beings. The householder shall have his life established in Brahma, shall pursue the deeper truth of all things, and in all activities of life dedicate his works to the eternal being. Thus, we have come to know that what India truly seeks is not a peace which is in negation or in some mechanical adjustment, but that which is in Shivam, in goodness, which is in Advaitam, in the truth of perfect union. India does not enjoin her children to cease from karma, but to perform their karma in the presence of the eternal, with the pure knowledge of the spiritual meaning of existence, that this is the true prayer of Mother India. He who is one, who is above all color distinctions, who dispenses the inherent needs of men of all colors, who comprehends all things from their beginning to the end, let him unite us to one another with wisdom, which is the wisdom of goodness. Now, my lord, this is the end of a Veda, because an Upanishad is usually, my lord, the last portion of a Veda. But even, my lord, in the Puranic literature, I'm just giving an example, my lord, the concept has been to look at all human beings. In all human beings, the concept is always you look at all human beings. For instance, my lord, in one of the 700 shlokas in the Durga Saptashati, there is one which says, Ya Devi Sarva Bhuteshu. The word Sarva Bhuteshu is necessarily in all human beings. Nyaya Rupena Samstita. That is, that element of justice is celebrated by, well, this is important because there has been a tradition of acknowledging equality as fundamental even in religious faith. It is not that equality is only secular equality, which has happened as a result of constitutions and so on. But it is.
Article 25(1).
Yes.
All persons are equally entitled to freedom of conscience. No conscience is superior to any other conscience.
Completely, my lord. And this itself, this all persons equally entitled. Now, my lord, let me deal with that word conscience, because that was one question which my Lord Justice Bakchi asked, and it was also in the context. If this is which volume? Additional volume. My lord, if your lordships would take up volume 1 of my additional materials. PDF page 3.
PDF?
My lord, PDF page 3. It is printed page 2, my lord. I'm sorry. Printed page 2,
Volume?
PDF 3.
Volume? What's the volume?
Additional volume number. Additional research material.
What?
Your lordships notice the word conscience. Page 2, my lord. Lord, this is the bigger Oxford Dictionary, the 17-volume dictionary, which I'm referring to here. Please see conscience. And if your lordships will see on the right-hand side, knowledge within oneself, consciousness, conscience, know along with another, to be privy with another to a matter. Left-hand column, my lord. Page, my lord, printed page 2, PDF 3. Column 1.
Knowledge within oneself.
Yes. Your lordship notices that, my lord? Conscience. Your lordship has found that. Now, please go to item 1. Inward knowledge, consciousness, inmost thought, mind. Then 1A, inward knowledge or consciousness, internal conviction. Then, my lord, if your lordships will go to the right-hand column, my lord, in the middle column, I'm sorry, column 2. In column 2, item 4, the internal acknowledgement or recognition of the moral quality of one's motives and actions, the sense of right and wrong as regards things for which one is responsible, the faculty or principle which pronounces upon the moral quality of one's actions or motives, approving the right and condemning the wrong. And then on the right-hand column, if your lordships will find number, my lord, just below number 9, my lord, please see 6. I'm sorry, 6, my lord. Practice of or conformity to what is right, equity, regard to the dictates of conscience. Now, my lord, this finds an independent place, as your lordships will notice in this. I have, my lord, also given excerpts of in relation to the etymology of religion and so on and so forth. But, my lord, let me take your lordship straight to page 92. This is running 91, PDF page 92. This is, my lord, please see page 91. This is from the Encyclopedia of Religion and Ethics, Conscience. Does your lordship notice that, my lord? Conscience operates, page, my lord, 91, printed page 91. Conscience operates when the individual passes an intellectual judgment on definite acts, accomplished or purposed of his own, and decides whether these acts are right or wrong. Such judgments, being self-regarding, are always accompanied by self-satisfaction or dissatisfaction, according as the individual feels he has fulfilled or fallen short of the moral law. Well, there is a description of this faculty of conscience. Well, the reason why this has been put separately is it may travel with religion, but it may travel even independent of religion. So it is wider. It has got its own place, my lord, shall we say. The ability to discern, that, my lord, is a moral judgment. That moral judgment, my lord, sometimes may be influenced by religious factors, but other times, my lord, can be purely a rational decision based upon reason and, my lord, in a sense of equity. So therefore, my lord, I submit the word conscience also has a standalone place in 25.1.
Need not be related to any religion.
Exactly. Exactly.
The latter part of 25.1 relates to a religion.
That is why, my lord,
where it coincides.
There it coincides. And that is why, my lord, this equality of all conscience, freedom for all human beings to profess their conscience and act according to their conscience, it's, my lord, an innate freedom. And that freedom has been so solicitously preserved. The reason why, my lord, the general application of the principles by the majority in Sabarimala. Well, there are 2 points. One is about constitutional morality. The other is just implying all part 3 articles in Article 26B. Well, that is not correct. Because Article 26, as your lordships have seen, does not have the same provisions as in 25.1. And the omission of that, my lord, cannot be done on the basis of implied reading. It cannot be undertaken, my lord, on the basis of an implied premise that because the Constitution exhorts liberty, equality, and dignity, that it follows a fortiori that other articles of fundamental rights cannot be completely obviated and must influence the construction of 26B. That, my lord, is the legal error. And I submit the reason is these rights belong to an area which Justice Bagchi perceptively remarked in the opening day. It is a non-secular area. It is an area between yourself and others and yourself and your maker and your personal space. Well, this is a different space. In this space, the articles may have a bearing to the extent that if you're going to act in accordance with equity, one must assume you would act equitably towards other human beings. But that, my lord, is not the test. Whether juridically can it be said that the articles in part 3 flow into 26B silently without there being an express incorporation? This is, my lord, the question. And this conclusion, my lord, has been derived from, my lord, a slightly broad-based preambular understanding, quickly leading to the fundamental rights, and also referring to 17. 17, my lord, is not irrelevant, but that is already taken care of by 25(2)B. That is the point. 17 also has been taken care of by 25(2)B. Therefore, my lord, this test is not the correct test. That is why I said, my lord, I'm sitting on the side of the review petitioners, because according to me, the exposition of law by the majority on this is not correct. My lord, on the question of constitutional morality, my lord, there are 2 points of view.
Mr. Gopal, before
Yes.
we move on from content.
We are not able to, please repeat.
My lord, the previous point is I'm saying that as far as 26B is concerned, it is not subject, my lord, to part 3 rights, which is the position in 25(1). And what Justice Chandrachud and, my lord, Chief Justice Mishra have done, the majority opinion, is that they have infused those articles and those guarantees for the purpose of interpreting 26B. This is one. The second error, my lord, is the error which the learned Solicitor General pointed out in 25(1). They read equally entitled to mean that it also meant gender equality. Well, it's to all persons. So that is also, if I may say so, not necessarily a conformist reading as far as 25(1) is concerned. And I submit, my lord, because of these 2 errors, I submit that this position is not correct. The majority judgment is not correct on law. But I now deal with the point relating to constitutional morality.
One thing.
Sorry.
Let's say so. See, with regard to, you said this in the context of conscience, there it becomes non-justiciable.
Yes.
It becomes non-justiciable. Therefore, the court cannot go into the rationality of that conscience or the quality of that conscience.
My lord, may I? I've understood.
And therefore, there are certain aspects of religion which the court cannot sit in judgment of.
My lord, may I just go a little slowly?
There where religion and conscience are interlapping or overlapping. Sorry.
My lord, let me take the case of first conscience proprio vigore by itself. Then I'll deal with conscience and religion. My lord, conscience, your lordships are right. The extent of rationality, the extent of what is being processed by the conscience of a person is not open to judicial review. But, I now say a but, and I say it very humbly, that if it manifests in an act which impacts rights of others, that is, it assumes the form of an action, a physical action, then in that case, my lord, a court may look at it. But there, my lord, it is no justification to say that I was propelled by my conscience to do something. You will have to justify it with reference to legal principles or legal defenses which are available. Let me come to the more difficult question, which is between conscience and religion. My lord, here, if I may say so with respect, there can be overlapping. This overlapping can be, my lord, again, it really belongs to the realm of faith. That is why, my lord, I have kept this word faith completely away, because that is completely the subjective experience of the believer or the worshipper. In that area also, my lord, you will not be able to interfere. But What you can effectively account for is the existence of a faith, because it's necessary for establishing the right to know the tenets of the faith, so that you can uphold the practice or uphold the rights which are being claimed, and also so that you can see whether any invasion by the legislature, either under 25(2)(a) or 25(2)(b), my lord, is disproportionate, excessive, and actually obfuscates the freedom itself. To that extent, my lord, you certainly can look into it. Now, my lord, one last comment before I answer, my lord, one more question. My lord, in these written submissions, I have actually listed, my lord, all the dates, very much like what Mr. Sai Deepak did yesterday. But your lordships will notice the word every denomination occurs without fail. And it is in the context of religion, every denomination must necessarily mean, my lord, religious denomination. So, my lord, the big religious denomination subsumes within it all sections thereof. My lord, I have had a look at the various questions. My lord, I therefore submit that the definition of religion as propounded by Justice Mukherjee, although he said, I can't give a rigid definition, but later, my lord, he says it's a system of beliefs and systems of belief connected, my lord, in an organic whole. My lord, that definition should be accepted. I have said so, my lord, in my written note of submissions. Now, my lord, I'm open to
Yes,
any.
Mr. Subramaniam, just following what fell from sister, my question half answered there. The 25, just above that is right to freedom of religion. But then 25 uses the word freedom of conscience and free profession, practice and propagation of religion. So, is it not an indication that conscience itself can be equated as a religion itself? Pure conscience, devoid of any formal religious association with it, by standalone, itself can be equated, because just above that is right to freedom of religion. But then the word is conscience and religion is with regard to free profession, practice and propagation of religion. Can it not be just a standalone? My pure conscience can also be equated with that of a religion?
My lord, there are two answers to it. In terms of, if I was a moral philosopher, I might say that it could stand on as high a footing as religion. But my lord, that is not the lens which one must employ for judging this particular expression. I would say, my lord.
So why I'm saying this? Because
yes,
this is
certainly.
individual right.
It is.
Individual.
It is.
It's not collective.
Yes.
I stand alone. I can also have my own. I say my conscience and the constitution equates it with a religion.
My lord, there is a distinction between conscience and religion. Religion is in the context of a set of beliefs enjoyed over a period of time, established, my lord, doctrinally. That might be external to the person. So religion in that sense is, they could be overlapping, as I said, my lord, in terms of the acts of conscience. But in terms of calling it as religion, my lord, if your lordships were to use the word religion as an adjective, that is, as a word, that it is as important as religion, I don't think, my lord, I would have anything to say, yes, it is as important as religion. Because, my lord, there can be a host of people who are agnostic, atheistic, and they all, my lord, may have the soundest and most robust conscience. It's perfectly possible. So I would say that conscience does have a unique place in the setting of Article 25. Your lordships can say it is perhaps as exalted as religion, but the meaning, my lord, may not be identical. My lord, if there's any other questions, I'll be very happy to.
Any submission on
I have given, my lord,
constitutional morality? Any submission?
my lord, on constitutional morality, my lord, I just, if I may say so, it just slipped my mind. My lord, constitutional morality does exist, my lord, as a concept. It is not completely an outrageous, or it is not a concept which needs to be discarded from consideration. It has value. And the concept is born out of, my lord, shall we say, not only governance, your ladyship is right, it's also out of governance, but more importantly, my lord, out of the spirit of the Constitution. In other words, there is something called, my lord, a golden thread, which keeps the Constitution organic, whole, and also lends to the Constitution the ability to be a living tree. Well, the reason why our Constitution is different from other constitutions in the world is this is a living tree. This is meant to actually talk to us in the present. It is meant to be a living document. And that is why, my lord, we derive strength from the Constitution. So, my lord, constitutional morality, viewed in terms of the spirit of the Constitution, it is a reasonable expression. It may help you to accentuate certain aspects of, my lord, a declaration. But is constitutional morality a doctrine of independent constitutional sanctity, that it can be invoked for the purpose of avoiding or annulling or declaring rules or legislation? I'm afraid no, my lord. You have to look to the specific provisions of the Constitution, and there may be more than one of them. The fact that there are more than one of them does not make it, again, constitutional morality. But the phrase itself, my lord, should not be, if I may say so, it should not be debunked. It is a phrase which you should retain, but it is not a doctrine of negation as far as that is concerned. Then what is the meaning of the word morality? Again, my lord, I have plenty of extracts. I have referred to them, my lord, in my submission. My lord, for the present, I would say that although Dr. Dhawan was kind enough to say it is a slightly restrictive conclusion, is that Justice Nariman said something morally abhorrent to civilized ideas in a society. That, I think, my lord, is reasonably narrow, but it also accords with the ideas of morality in the other parts, that is in the subsidiary in 19.2, 3, 4, and 5, and 6. So therefore, you will have some consistency in reading the word morality. The word morality, my lord, in Article 25 and 26 is not constitutional morality of an overarching sense, but is intended to be a restraint, only that much which is necessary to ensure that it can be a trespass on your fundamental rights. So if you read it that way, well, the logic which I applied to 25(2)(a) and B, I am saying the same even in respect of morality. That what I appealed to your lordships was, please engage a narrow but well-tailored scrutiny of 25(2)(a) and B. Then the same by analogy. My lord, analogy is one of the ways by which you can ratiocinate. So by way of analogy, even in respect of the expression morality, your lordships may give a limited meaning which comports with the subject of the article. So morality, my lord, for speech may be different from morality qua religion. It may not be, my lord, always the same. That is why the placement of morality with reference to the nature of the right which is being exercised is also relevant. For instance, my lord, for freedom of association. So, my lord, I submit with respect, we should not think that this is no more than an exalted 19(1)(c) traveling in 25. This is an independent freedom which has been guaranteed under 25. And above all, my lord, the most vital consideration for your lordships to keep in mind is the equality of all religions and an interpretation which conduces to all. And my lord, this will be something which the constitution makers truly wanted to accord in spirit, namely the equality not only to men, to persons, but equality to all religions and to practitioners of all religions. And I'm more than happy to answer any other question.
If I understood you correctly, you said that constitutional morality cannot be a ground for judicial review. If I understood you correctly.
It cannot be an exclusive factor, my lord, in judicial review. That is, it cannot annul, shall we say, a statute judicially reviewing.
No, but then how do you?
It is not a limitation. I'm grateful to my friend.
How do you explain that morality is restricted by the word constitutional? Whatever judicial review is done by the courts basically has to be to harmonize the provisions of the Constitution. So if morality looked in the scheme of the overall Constitution, how can you say that it should not Why cannot be the ground only for judicial review?
My
But
lord, it could be.
ultimately, it is not going beyond the constitutional. The morality has to be restricted. The test has to be within the constitution.
My lord,
The constitution is sacrosanct.
my lord, I've understood your lordship's question. My lord, may I give an example? It is not that Article 14, which are anti-discriminatory, non-arbitrariness provisions, do not embody a moral principle. They themselves embody a moral principle. Begar establishes a moral principle. Likewise, my lord, 17 is a moral principle. And my lord, I submit with respect, therefore, if your lordships were using these as provisions, they may suggest additionally a dimension of constitutional morality. But when we use the word constitutional morality as some kind of a doctrine without reference to the constitutional provisions, that is when, my lord, the doctrine becomes, if I may say so, deeply vulnerable. But if you traced it, as you said, to different articles of the Constitution, my lord, a certain morality can speak. My lord, when we talk about judicial conscience is upon an application of all these faculties. So therefore,
In other words, what you are saying, you can use this, the concept of constitutional morality, to understand the constitutional provisions themselves. We can take it.
yes, that is actually, my lord, my submission.
Cannot be a test or to strike down legislation.
Yes, it cannot be a test which is, my lord, an independent test, which is therefore a limitation for being exercised in judicial review. My lord, is there any other question?
Thank you, Mr. Gopal.
We want to know all human beings are bound by conscience, irrespective of the nature and quality of the conscience.
My lord, in fact, in my additional submissions, your lordships will find this is the preamble of the 48 declaration, exact words. What your lordships uttered is the exact preamble of the 19th Universal Declaration.
That is what makes a Homo sapien different from an animal,
Completely.
which we don't realize.
Thank you, Mr. Gopal. Thank you very much.
I'm very grateful. So, my lord, I didn't read this. I'm sure your lordships would read them. And I just thought I would touch upon the aspects which have arisen as a result of it. Grateful.
Please, your lordship. My lords, I'm appearing for review petitioner. Sorry. I'm for a review petitioner.
We know that.
For the former chief priest of this Shabrimala temple.
Let me tell my lords what I intend to do. I'm not going into every one of the issues. Your lordships have heard many learned submissions on the.
We're supposed to wind up today,
Yes.
but we are granting one extra day, please. So bear with us and we need
Please,
to
my lords.
very quickly close it.
My lords, my aim is to do this. Your lordship has various issues. I want to bring it down basically to what is Article 25, what is Article 26, what are the parameters in these. Much has been spoken about religion. My lords, there is a lot to be said about religion as religion. But I'm more concerned about what Articles 25 and 26 say. And in particular, I want to answer certain questions which have been raised by your lordships during the hearing. which is why I'm not going to my huge written submissions. I'm going to a very small 6 propositions.
Better address your principles which you want to.
Absolutely. So, my lords,
Ignore our questions. We keep on asking questions.
my lords, what I'm going to address, my lords, are on these broad principles. It's all in one.
Yes.
6 broad principles.
In which volume your arguments are there?
My lords, my arguments are in volume 1.1,
Better we take this piece.
page
of paper and-
500, 507. My lord, at the time of filing, the petitioner, my lords, was the president of the VHP Kerala, and my lords is currently the general secretary of the Sabrimala Karma Samiti, as also the natural chairman of the Sabrimala Ayyappa Seva Samajam. My lord, can I just give your lordships the broad principles on which I want to go?
Yes.
Before which, I would like to answer your ladyship's one question earlier on what is conscience. My understanding of conscience, pure and simple, is it's a moral compass within which each one lives. If we understand that to be conscience, we look at it as our own moral conscience of what I feel is right and wrong, which someone else may not give him equal importance to. But there are what we have always called absolute rights, absolute wrongs, which are pernicious behavior, which you cannot claim protection of conscience. In that background, can I just take your lordships through these broad principles? First of all, religion, for all the learned discussion on religion, boils down only to this. It is an expression of belief in a superior force. A particular God is a personification of that belief. Why I would like to emphasize this is that, especially I know in the South, probably all over India, a temple is really an abode of a particular deity. It is where a deity in the form we want to worship that deity is. So, for example, if we take Ayyappa, Ayyappa has in various forms. Each temple worships that deity in that form, treating it as the home of the deity. For example, Guruvayur, while it is Krishna the child. The entire religious feeling is towards the deity in that form, and to that extent, please consider my primary submission, my lord. A temple, a religious institution, is really an abode of a deity. Which is where this question of essentiality test, I am not able to understand. Why? If it's a religious practice, it is a religious practice, and with freedom of conscience, which does not trample on somebody else's toes, I can follow my religious practice. The moment we say essential religious practice, it becomes a question of fact. That question of fact then is left to the courts to decide an ecclesiastical matter, which we say we will not do. It becomes a jury question. Is it essential? Is it not essential? And at the same time, we say the courts will not enter into ecclesiastical matters. So this concept of essentiality is not relevant. What is relevant is the concept of whether it is a form of religious worship. That is all. And whether that form is found either in the Shastras or through long custom or through long usage, or is the manner in which a group of people want to worship the deity. And my lords, we cannot go beyond that. My lord, where I disagree with some of my colleagues is that Article 26, I believe, certainly does not exclude Article 25. The two have to be read in tandem. The word class in Article 15, here again I disagree with some of my colleagues, does not exclude only those contemplated under Article 17, but will apply to castes as in communities, as in class as in caste, communities, others. But it is my submission, it will not apply to gender. Because where gender is intended elsewhere in part 3, gender has been referred to and has not, my lords, been passed in a generic class. The power of the state under Article 25 includes denomination. So according to me, 25, 26 have to be read together. The state certainly has the power under 25, 1A and 1B, qua denominations also. And there, to the extent that it was said that 26 is not subject to 25, I do not agree with that submission. I, on the contrary, say, yes, it will apply. However, my lords, the power of state under Article 25 would include denominations, but only qua class and sections. And it is my submission for the, although the disjunctive is used as or in Article 25, but only for reasons of social reform and welfare. My Lord the Chief Justice earlier said, which is the idea I subscribe to, that whether considering a particular practice and whether removing that practice is for social reform or not will be a matter to be decided in a particular case. What is absolutely barred by the Constitution, of course, for example, Article 17. But the others, what nature of social reform? And the social reform has to be taken qua the activity, qua the form of worship, qua the deity, and qua the manner of worship of that deity. You cannot take social reform in an abstract sense. You have to say, for the worship of this particular deity, in this particular form, this particular custom abhors the conscience. This particular custom should be done away with. Your ladyship referred to sati. That's a very typical example. Very typical example, should be done away with. But that will be tested on a case-by-case basis, and there are no absolutes so far as that is concerned. And there can never be absolutes. And so, while it is recognized that for a larger good, for social reform, and here my Lord Justice Bagchi pointed out that social reform could be read in lines with directive principles of state. When I look, and fundamental duties. When I look at the rights under Article 25, social reform or not, in keeping with the directive principles, you will find when you go through it, my lords, I'm not going to take your time, we do not deal at all in the directive principles with gender equality in the access to any place of worship, irrespective of the nature of worship. It is not even an aim to achieve gender equality. While the aim is to achieve gender equality in employment, in other manners, access to places of worship or freedom of religion does not include this concept of gender equality even in the directive principles. My lords, therefore, Article 25(2)(a) deals with secular activities in a religious practice, for example, property. 2B deals with the state's power qua particular institutions in the interest of social welfare and reform, although the words used, if you would kindly see, says providing for social welfare and reform or the throwing open of Hindu religious institutions, should correctly be read as providing for social welfare and reforms inter alia by throwing open the Hindu religious. It can't be, I can just throw it for no reason. But like your lordship said, that's a matter to be tested in a given case.
Very, very difficult to accept this.
Sorry, Malad.
Very difficult to accept this. Because if you accept that, it will exclude others also.
No, I put it in this manner. I am saying, please take the color of throwing open the Hindu religious institutions to the words preceding it. That is, actually, that should be the nature of my submission.
In terms of the defining or what constitutes social reform.
Yes. For that purpose, yes, you can throw open an institution, but you throw that institution open for the purpose of social welfares and reforms. That is the manner in which I'd like to interpret 25(2)(b). So it is not an absolute right. It is a right which is certainly circumscribed by the fact that the state can act in a larger good, but when considering the larger good, cannot open out the temple to and say X can go in or Y can go in without going into the question as to whether it is for furtherance of social reform or welfare. That is the submission I want to make to my lords. It has to be read together. It cannot be separated. The two have to be read together. My lords, so far as denomination is concerned, much has been said, many judgments written about denomination. My lords, I'm because of the time, I'm not taking my lords to the various interpretations. I've tried to concise my arguments as much as possible. Not so that. Denomination, basically, like I said, for religion also, I gave your lordships what you might feel is too simplistic a meaning, but that is the way we all understand it. Religion is a belief in a superior force. God is the particular God, the deity, the idol, is my personification of that belief. I bring it down to simple terms. Now, denomination.
Mr. Sundram,
Please.
is there not a fundamental contradiction in the argument if you say that we should read providing for social welfare and reform, inter alia throwing open? The fundamental contradiction would be that providing for social welfare and reform can only be for a limited section also, but here throwing open is for all classes and sections. So that is a different.
Yes. My lords,
social reform and welfare can be limited only to a particular group within a denomination.
social reform so when you open a religious institution to all classes and sections,
But social reform
you're
and
doing
welfare
so.
can be limited to a particular subsection also. But
Yes.
this is to all classes and sections.
Yes.
This is blanket. That is why throwing
All
open
or
is
some,
blanket.
all include some.
How can it be qualified by?
My lords, I read the word all in Article 25 2B to be all including any part of. All is not the whole class. Eliminating, it is a question of all classes and sections. That is, you have the right to open it to any class and section, which is necessary for social reform. But there again, please, my lords, keep in mind that my submission is classes, sections does not include gender. That is but looking at the words themselves, when I say to all classes and sections, obviously a particular notification of the government, a particular action of the government, a particular law of the government would be pertaining a certain class. It need not be the world at large. It need not be the world at large, but class would mean all those similarly placed will necessarily, otherwise it runs foul of Article 14. So when we say to all classes and sections, all similar classes, but not universal all, that it's all or none.
Providing for social welfare and reform, that is not qualified, but throwing open is only restricted to sections of classes of Hindus.
Yes, absolutely.
Reform can be to any religion.
Yes,
On that ground it can be made. But this restriction of throwing open is only, that is why it is qualified for sections of Hindus.
Absolutely, which is why if a lordship also sees,
it cannot be read in the same thread.
In which case, my lords, I may explain why. For example, if we take, my lords, Muslim places of worship, my lords, definitely it is not thrown open, and the state throwing it open for access outside the religion may not come up at all. But most institutions, temples, Hindu institutions, like take our Sabrimala itself. It is, my lord, religiously Catholic. Any religion, person of any religion can come in. It's not only a Hindu. Provided you do.
No, even in dargahs and all, everybody can go.
Dargah, yes.
So there's absolutely no restriction of anybody.
Dargah, yes. But I'm not sure, my lord, on whether the rule is for all mosques. Dargah, yes.
Different sections have that.
It's only in respect of a mazar, not when it is a mosque, there's no bar for a woman to enter. It's a mazar.
Not women, my lord. I'm talking about people who do not profess that religion at all. I'm talking about
There
their
is no
entry.
bar for.
No, my lord was putting the question to me.
Non-Muslim to enter a mosque. The question is whether they can worship inside.
Inside. That is the point. That is the point. Because if your lordship sees, you're asking me the question on B,
Well,
whether the
same-
first part of
same
B,
reverse thing will apply in respect of a temple. A non-religious, a non-Hindu can definitely enter a temple, but the religious practices may not permit offering of namaz inside the temple.
but your lordship is talking about a mosque, but I'm talking
Yet
about,
just put the reverse.
yes,
The same injunctions may apply in all religions.
in some temples, not so. For example, Sabrimala itself,
Does Sabrimala permit offering of namaz inside the temple?
not namaz, my lords, the
So-
form of worship, which is what I'm coming to.
So the form,
You cannot sit, for example, I can't go to Tirupati when the Suprabhatam is being played and say, I want to sing to the praise of Lord Shiva at that moment. When I go to a temple, I accept the form of worship of that temple.
your point.
What we are asked today in this case is to see whether I can insist on access,
Sir, your point.
changing that form of worship. That is the whole moot
Your
question.
point is well taken, but the 25B does not speak of worship, it speaks of entry.
I'm coming there. My lords, the entry itself can be thrown open today, but the question before your lordship is, if a particular institution says the nature of the deity is such that it belies the entry of a certain person, would the state then come in and say, I'm sorry, you cannot belie the entry of such a person unless the refusal is pernicious. Refusal traces to Article 17. The refusal traces to something which is shocking to the human conscience. And that's why, as my Lord the Chief Justice said, that's a matter which will have to be seen from case to case, but cannot be said as an absolute.
Mr. Sundaram, the thrown open part is very clearly, it is reiteration of 17.
Absolutely.
Is replantation of 17.
Absolutely.
Reiteration of 17, that part probably is not.
That is why I was answering my Lord by saying classes there are similar sections which are of a similar class. You cannot distinguish.
Even sections of the Hindu.
Absolutely. Absolutely.
Therefore, that no, there should not be any mistake that 17, a constitutional declaration and a very powerful right of 17, that has been reiterated with reference to the.
My Lord pleases. In fact, that is, I couldn't put it in any other way, my Lord. That is my submission. My Lords, I'm now coming to what is a denomination. My Lord, denomination is nothing more, because we have realized one thing. If a temple is an abode of God, God is my personification of my belief, and that particular God is in a certain form. My denomination is in what manner I wish to offer worship, and to God in what form. It's not that you have to go further into denomination. If I see God in a certain form and in none other, and I see his worship in a certain manner and none other, I form a distinct class from people who see God in another form, or who want to offer worship to him in another form.
Need not be in one form only. It can be in many forms.
That is my choice. Exactly, your ladyship is right. That is my choice. But let us say there's a collective group of us who see him in a particular form, and who see a means of offering worship to him in that form, in a common way. We are a denomination. We need not go further by tests of denomination. Is there an institution? Is there a purpose, etc.? We are a group, we are a denomination. And to answer my Lord Justice Bagchi's question, what if within the denomination can you not debate? Of course you can debate. On the contrary, you can go one step further. You can say, I'm sorry, a group of this denomination doesn't agree with this form of worship. We have a totally different form of worship. You can form another denomination. That itself will become a denomination. Manoj, so let us not go into this concept of denomination like a great matter to be legally discussed as to what would legally connote
What you
it.
are saying, denomination is something which is to be left to the collective believers.
Absolutely.
Don't go into this, that's all. Whatever may they do, it is their common belief. Small variation or same thing, whatever we can say, so long as they decide to have a group and then they decided to have faith and practice and profess, and
Absolutely.
that lead at that.
That's why I said, my lord, my attempt is to very simplify the two articles. I know there's a lot of literature on it, but I want to simplify it because we are dealing with 25, 26.
Are collectively managing their affairs.
Absolutely. My lord, therefore, please see the definition I have given, my lord.
Need to have a formal organization as such.
You don't need it.
See, that is the reason, as you rightly said, you can't dissect 25 from 26. It's a progression from that. You have to, it's a next step.
Absolutely.
You become, see, the denomination will become part of 25. Additionally, how to manage and administer.
So a denomination itself is also protected under 25,
Naturally.
Yes.
not only under
Whichever way you
26.
look at it, either through your very common believers or by your own self, whichever you like it, that's why rights and liability are determined in 25.
Absolutely.
So far as the belief, practice and profess is concerned.
In fact,
In
that's
terms
what
of management, other things, so administration, that comes.
would be different. My lord, there also owning property could be a secular activity. That is something else.
Correct.
But my lord, this is why I disagreed with my learned friends who said that 26 excludes 25. Because why? I see 25 as an added ammunition for an institution, for a group of people. It's a right to practice a religion. So if I want to practice a religion, I can practice religion in my form of worship, provided it's not pernicious. Malad, that's why please see my definition, what I've given to the denomination.
See, propagation of religion can also be a matter of religion. See,
It is. As your
therefore,
ladyship knows, I can be an atheist and that can still be a freedom of conscience.
propagation of a religion is also coming under 26B.
Yeah, absolutely. You're absolutely right. Absolutely right. Yes,
It is a matter of religion.
it's a matter of religion. So therefore, the two are intertwined. I said 26 cannot be divorced from 25. The two go together.
Your point number E has been broadly argued by everyone in the same manner. There is
No,
probably there is no
my lord,
variation.
I saw there was a slight digress because there was some arguments taken before your lordships that 26
Does not say subject to.
is, and is not covered by.
We understood your argument. No problem.
That I want to dispel that from my submission.
No.
That's all my aim.
Your point E is only with respect to the meaning of denomination.
Yes.
It is broadly,
Manager administrator.
Well,
broadly argued in the same manner.
point E, I want to say it's nothing more than a collective group who offer worship to God in a matter distinct from others, who have a common religious belief but express their worship in a different way. That is, we all might have a religious belief, common religious belief. We are all Hindus, but we express it in a different way. Well, if we accept that is a denomination,
Come to F.
I'll come to it. If we accept that that is a denomination and we accept that 26C B gives the powers to manage my affairs in a manner of religion, then my form of worship of the deity who reflects my understanding, which is the Nastika Brahmacharya, the question then is not an absolute. Article 14, how are you distinguishing against women? That is not the question. The question says your denomination's manner of worship of a deity in a particular form. Is this exclusion rational? That is the only test.
I will tell you why. 26 is on a different issue with respect to administration and management. This public morality, health, it will come only with respect to management and administration.
Absolutely.
Otherwise, you go on to 25.
25.
You will not have any better right than the believer.
Which is why my lords will say.
Believer, a common believer, you are only a manifestation of those persons. That's all.
Which is why my F, proposition F, according to me, part 3 will apply to 26 also. Part 3 applies to 26. In fact, F, I have said.
But restriction only with the public order, morality, and health, that's where the problem comes. If you come under 26(2)(b), 25(2)(b), then there is a matter. You can't say it will come under, partially it will come under public order, morality and health, then other part will not come. It will come.
I said both are intertwined. That is my submission.
That's correct. That's
They
what
are
we take it.
intertwined.
We take it up.
My lord, let me explain
Part
why.
is conspicuous by its absence. Otherwise, they could have said subject to part 3. Or they could have said subject to Article 25(2).
My lord, there,
Said in Article 26.
there my answer to your ladyship is this. If 25 gives me the right of freedom of religion, it is a fundamental right of mine, like every other fundamental right. It is tempered by its own restrictions. Like every other fundamental right, it is tempered by its own restrictions. If I am given the fundamental right of religion, it is my right, which is an individual right, or my right as a collection of individuals, it's our right. So we trace our right to 25. 26 says the state indicates, state will not interfere in the manner of your exercising that right. Subject again to 25(2). So I'm saying you can't divorce 25 and 26. My right, your ladyship will see
That's
26.
what Z was also saying. Your rights are subject to 25(2).
And 26, my right under 26,
Then we got it. We understand. We appreciate that.
my right under 26 is a manifestation of my right under 25.
Okay, we appreciate that. We follow it.
And if 26 does not provide for any restriction other than public order, morality, and health. However, we cannot say that so far as 26 is concerned, 25(2)(a) and B cannot be applied. It can be. So, my lords, how, I ask myself, could anyone try to divorce 25 and 26? You cannot do so. Foundation, the fountainhead of your power is 25, of my right.
It cannot be in piecemeal. Either
Cannot be piecemeal.
either you take it or leave it, that's all. All
This
right.
is one area where some of you are at variance. We will examine. it.
Please, my lord. But I'm giving the reason why I am canvassing it from the angle I am. The reason I'm canvassing it from
All
that
that we
angle,
can say is your approach appears to be more balanced than the others.
I would think so, my lord. Whether your lordship thinks so is a different matter.
Subject to hearing them.
No, the only point I want to make is this. My lords, I also had an argument saying that 25 was individual, whereas 26, no. The right to profess my
We
religion.
understood it fully, no problem. We understood it fully. That's what.
Well, my lord, these are the broad propositions on which I would like to. I have, my lords, placed an aid memoir elaborating these. I'm not going to take my lord through it, but I cut short everything in a different way from my original submission based on much of what I'd heard and much of what I felt I would like to address my lords on. But in short, my lords, what I would like to say is this. In short, what I would like to say to your lordships is this. Number one, classes does not include gender. Number one. My lords, I've given various reasons in my aid memoir, but I'm just summarizing.
Yes, yes.
Class under 25(2)(a) deals only with secular activity. The 25(2)(a) deals only with secular activities, not with theological, not with religious. Article 25(2)(b), when referring to classes, does not refer to gender.
That's right.
And therefore, the power to throw open for a gender is not traceable to 2B. If at all it is claimed, it can only be claimed on the right of 14, because part 3. But if you take 14, you must see whether there's a rational, intelligible differentia, rational reason for it. Now, if you take that reason as being the reason being it is felt by this people who are worshipping this particular deity in this particular avatar, in this particular form, that being a Nastika Brahmacharya, this form of worship is called for. And if that is not found totally arbitrary, illogical, perverse, or reprehensible, your lordships would not interfere on a matter of somebody claiming a right because of Article 14. 14 has no role. My lords, and finally, the submission which I have to make is that 26B is nothing but an elaboration of a right I am already granted under 25(1).
That's good.
My lord, this in short are my submissions.
This is the first point you were saying. That's the first thing.
My lords, I have given an aid memoir. I just want to refer there, my lords, to page 5. My lords, page 4, Roman 3, Roman 4. The pages are at the foot of the page. What is the meaning of the expression sections of Hindu occurring in Article 25(2)(b) of the Constitution? Article 25(2)(b) itself, referring to classes and sections of Hindus, has to be kept in reading in mind with Article 17, cannot be taken as encompassing gender, especially since Article 25(2)(b) refers to Hindus, includes offshoots of the same, and not to other religions. Because your lordships will see the explanation included Jains, Buddhists, Sikhs, Buddhists, which are offshoots of the Hinduism itself, and not to other religions, which makes it clear that classes referred to therein, as is contemplated in Article 17 and in juxtaposition to Articles 15(2), 16(2), where there is an intention to include gender, it is specifically mentioned. Sections of Hindu is only used in the context of Article 25(2)(b), being Hindu religious institutions. Concept of gender would be part of 25 as a whole and not to 25(2)(b). The intention of the makers of the Constitution cannot be presumed to ensure gender equality in the context of Hindu religious institutions to the exclusion of all other religions and their institutions. Your lordships will find I'm supporting this with this. Wherever gender equality is called for, there are specific articles dealing with it. My Lord Justice Bagchi said directive principles. Please see, in directive principles, Article 38, 39, deal with gender equality, but where? In providing employment in those areas. So
that is applicable for everybody.
So gender
across the board.
Across the board. So gender equality is not taken particular to a manner of worship. So gender equality is not an integral part of a manner of worship.
That too for Hindu religion. If it is there, it should be there for other religions also.
Absolutely. So my whole point is gender equality, while as a notion, is something which is to be furthered. Where it is required to be furthered is specifically provided for. Otherwise, it is not an integral part of that religion. If it's not a part of that religion and it is a rational manner of distinction, the courts would not impose Article 14, which is exactly what has been done earlier. By the whole genesis of the earlier case, if you look through it as a thread, it's Article 14 is the thread of the entire judgment. Whereas it is my submission, Article 14 has no relevance here. That is my submission. Now, please see, I've dealt in Roman 4, and I conclude with this, Malas. I realize that I did say I'd finish soon. Roman
25,
4, interplay of Articles 25 and 26.
Already argued, somebody we got you have noted your point now. See, this is again, you started with this only.
Yes.
That's agree.
Absolutely.
Note it down, that's all now, no issue.
Absolutely.
Yes.
So, my lords, I will conclude it with this.
Yes.
That neither Article 21 or 14 would have any dealing with it. When your lordships have the time, please see my note on it, but I didn't want to take more time. You've heard enough. But I wanted to highlight these were the aspects on it. Sorry? Which is this?
2 p.m.
May I please? So, Lords, we have heard the enthralling.
Procedural point,
lightning-
minor procedural point, nothing to do with the gravity of this case. This board is showing 7 judges for the last many days. It doesn't show 9. 2 names are missing.
I am religious, my Lord, but and my surname suggests, my Lord, that I should have read at least 2 Vedas. And as the story goes, my Lord, there were some Chaturvedis, my Lord, who were they wanted to create 2 more Vedas. So they were demoted, my Lord, and that's how we are here, my Lord. Trivedi. But I have read only some chapters of Rig Veda, my Lord. So I'll steer clear of that religious ground, except to say this, my Lord, that of course all councils have addressed that religion should be understood in the widest sweep. But there are 2 other aspects of religion, and that is, my Lord, one, that religion is associational by its very nature. One man alone, living like a Robinson Crusoe's island, cannot create a religion. So, and what we know is that when Lord Buddha, my Lord, had enlightenment in Gaya, then he came to Sarnath and he collected his friends and all, and they were the first people who were convinced about his revelations. And that's how, my Lord, Buddhism. So Buddhism is a religion is by nature associational, and that is also, my Lord, subject to correction by my Lord Justice Amanullah, my Lord. When Prophet Muhammad also had a revelation, my Lord, he also, my Lord, had to converse with his family members and friends and convert them, my Lord, to his thinking. And that's how, my Lord, it spread. So when 25:1 talks of religion, the lodestar is religion. Conscience, profess, practice, propagate religion. This constitution was not being made in vacuum. There already existed religions. An explanation 2, my Lord, in fact, mentions some of the religions, which I will be addressing as the basic religion. So religious denominations will be, my Lord, like streams flowing out of the basic religion. But religions existed, and these are the religions which they had in mind. It is with respect to those religions. I'm not saying that new religions cannot be born, my Lord. Some tribals are, my Lord, in Jharkhand, etc., claiming there's some Sarna religion, my Lord. They worship hills, trees, and so on, and they want it to be recognized. And state of Jharkhand has recognized, but central government is not yet recognized it. So new religion may come up. But as on the date of the constitution, there were religions, and those religions existed in the associational form. And the other aspect is, my lord, the framers had both the good and bad experience of religion. There was a time, my lord, in the 16th century, my lord, when state power was emerging, then it was asking for separation from religion. Religion, my lord, was controlling the states, especially in Rome, my lord. In India, and also we have seen that many kings, my lord, they used to declare state religion. Like King Ashok, my lord, he declared Buddhism as a state religion. So all the kings used to have the moment the regime changed, they would recognize the religion according to their choice. And they experienced, my lord, what amount of bloodshed there had been, my lord, in the struggle between Catholics and Protestants in Europe. Millions died in that battle to establish supremacy or their own existence. We also know, my lord, how there was crusades against Islam launched by Christianity. And we also know, my lord, how in the name of jihad, my lord, there was Islamic invasions in various areas. So as far as in India is concerned, my lord, we have a long period of growth of religion. More or less, there was conflicts, but largely, my lord, the denominations, the various philosophies, our evolution was based more on debates. Like Shankaracharya came to Varanasi and had a great debate with Mandan Mishra, and he made his wife, my lord, the judge, the first lady judge, my lord, of Bharat. So it was more on debate. I'm not saying there were no conflicts with Buddhism, etc. There have been conflicts. But far unlike that, we experienced clash of civilization and religious clash when, my lord, we were colonized for a long period of 800 years. First by the Sultanates, then the Mughals, and then the British. So this clash also, my lord, was the experience at the time when this constitution was being framed. Simultaneously, we were witnessing civil war because Muslim League had decided, my lord, to get the partition of this country based on religion. And they formed the Islamic Republic of Pakistan. So this negative experience was very much alive when this constitution was being framed. On the other hand, my lord, our civilization, if it is surviving today, we owe a lot, my lord, to the Hindu religion, the religious denominations, the bhakti movements, and the great acharyas, my lord. It is because of them, my lord, that this civilization is alive. Otherwise, there was enormous attack, my lords, on this our civilization. So therefore, this was a positive aspect of religion, and that's why, my lord, the framers have placed the religious denomination separately and conferred or recognized their right. Religion existed before the Constitution. It's not a gift of the Constitution. So 26 is a recognition of that. These denominations have united the country. So the unity aspect, religion unites, religion also divides. These are the two aspects which were born by them, which was very much alive in their mind when this various structure was framed. Public order was required so that we don't have the civil wars of the kind which we were having. So that without that, there can't be fraternity, there can't be secularism, the different religions cannot interact, cannot fraternize. Therefore, we need public order. The one and only aspect on which Article 26, if we look at closely, the three heads, public order, morality, and health. Public order and health are actually facilitative. They are not limitations at all. In order to practice our religion, we need peace, harmony. So public order and health, if there is some pandemic, like COVID, then the state has to facilitate the exercise of religious rights. So there is one and only one head on the ground of which there can be interference, that is morality. Because we also had the experience of Sati Pratha and Dasi Pratha and so on. And as time comes, the new dimensions, new false lines may be discovered, and therefore morality is the one and only ground. And therefore they wanted really to strengthen. So my request is that with this objective which they had in mind, please give a verdict which brings out this fundamental right to religion in a robust manner. It should not be a matter of a plaything where the governments come and go, and they interfere at their whims and pressures for their political ends, etc. Because religion is very much intertwined with society, the social life, politics also. We see, that if you are contesting election, the first thing you have to do is to go and visit a temple. So the temples, again, have a central place in our history. I've been reading the Professor Dr. Upinder Singh, former Prime Minister's daughter, Manmohan Singh's daughter, and she has mentioned that in ancient times, these temples functioned as banks also. Because when the ships used to sail, the Cholas and the Cheras and the Pallavas and Rajshekharas of Kerala, the ships used to sail east and west. They needed a lot of finances. It's the temple, which was the central piece, and that's why the temples bore the brunt of attacks, of Ghazni and so on. So therefore, we should not put any construction on 26, which dilutes the rights which have been given there. Whatever legislation is permissible is indicated in 26. That is clause D. Administer such property in accordance with law. They can certainly make a law, movable, immovable property. Of course, the denomination will have to acquire the immovable property in accordance with the ordinary law. They will have to pay registration fee, etc., unless exempted. So therefore, this right is very important for safeguarding the freedom of religion. Now also see, my lords, how do we bring in 25(2)(b)? That's one of the major issues. Your lordships have noted that unlike Article 25(1), 26 does not say subject to other provisions. Your lordships have noted that. Your lordships have also noted that nothing in this article shall affect, that is this article 25(1). Your lordships have noted that. Your lordships have also noted that Article 26 does not say subject to. That's the third fact. The fourth factor is that during the Constituent Assembly debates, there was a specific proposal, that there was an expression initially that consistent with the other parts. A similar phrase was there. If your lordship has this paper. Kindly at page 32. Paragraph 49.
Yes.
clause 17. And this was in the subcommittee. The subcommittee on fundamental rights constituted by the Constituent Assembly had submitted a report dated 3rd of April 1947 to the Chairman Advisory Committee. It contained an annexure relating to justiciable fundamental rights, clause 16-17, correspond to 25-26. Please have 17, the last line, consistently with the provisions of this chapter. At the next stage, this consistently was not accepted, and the Lordship will see 21. There was no rider. It was not subject to anything. And that position continued even in the advisor's draft at page para 51. Clause 20 remained more or less the same except slightly restructured. Then para 52, that is in February, October 1948. It was in October 1948 the drafting committee considered the suggestion of Shri B. Patabi Sitaramaya and 6 others and introduced the clause subject to public order, morality and health. That's how this expression came. And they did not accept consistently with the other provisions of this part. So that's the fourth factor. Now, given this position, it is my submission, respectfully, my lords, that Article 26, the rights cannot be eroded and made subject to 25(2). So far as A is concerned, my lord, that property can be regulated under D itself, 26D. But 25(2)B would not be attracted, my lord. Now, even if we consider, that's the alternative, that even if we consider that religious denomination is also associational and also exercises the freedom of religion, which is encapsulated in Article 25(1). And since that article says subject to, and 25(2) relates to 25(1), even so, my lords, the question will be, how do we apply this? This is an enabling power, your lordships have noted that. That is, state can make a law. Now here, my lord, I submit that Devaru has gone wrong completely. And it needs to be overruled completely. The reason is, it says that 25(2)B and 26 are powers of equal authority. They need to be harmonized. But I have, with respect, I'm not aware of any canon of construction by which a fundamental right would be required to be balanced against the power of the state to make law. Kindly come back to Article 19, my lords. How do we, my lord, where is the question of harmonizing, my lord? That only question will be, has the state made a law within its competence? That is one. Is the law so made, my lord, standing the test of fundamental rights? Is it disproportionate, unreasonable, unjust and unfair, manifestly arbitrary? If it passes that test, then law will be valid. Where is the question, my lord? If this equal authority with lawmaking, kindly apply that law to 19 and see the consequence. So 19(1)A will have to be balanced with 19(2). I mean, with great respect, sir, I have this is something which is not permissible at all. Once, what notwithstanding as has already been submitted, or nothing in this clause only means that state can make a law. but it must be having nexus with the heads. Meticulously different set of heads have been provided in 2, 3, 4, 5, and 6. And the lordships have said that if a law is impacting trade and business and also 19.1a, then you have to test it under 19.1a. But here, we are required, my lord, to balance it with 19.2. Like similarly, 19.4 association with 19.4. And added to this, Lord, if you add morality, make it constitutional morality here, the whole structure goes for a song. So this constitutional morality as a concept you may have, may not have. The question more pertinent is, can you read morality as constitutional morality? That's the issue. That is what the view of Justice Chandrachud is, Lord, in that case. So that maybe, Lord, you can keep it out for some other day, although in my view, Lord, it doesn't help us in any way. Every time a law is made, test will have to be, do you pass this fundamental right test or not? So therefore, Lord, this question of balancing this 26 with 25(2)(b is with great respect, my Lord, wholly incorrect.
So if an issue arises, the state has to justify it on the basis of 25(2)(b).
Yes.
The burden is on the state.
On the
Just
state.
as under 19(2), the burden is on the state to justify it.
So if the law is made, is valid and tailored to these heads, if it is permissible, then
It
this
cannot
law.
be violative of fundamental rights because it's a reasonable restriction.
Now kindly see,
If
Lord.
you come to Article 19.
Yes. Now 25(2)(b, supposing a law is made by legislature. A law will be made under Article 245, 246, subject to the provisions of this Constitution, which means subject to 26. How will that law will have to, your lordship will examine, is this law breaching the right under 26? Your lordship will not be curtailing the right of 26 because of that. So the essence, the core of the right to manage its own affairs in matter of religion and to administer such property, that law cannot be taken away. If it takes it away, then 26 is breached. There is another aspect, my lord, the lordship will see at page 9. I have mentioned 2 or 3 judgments, my lord, about the approach to fundamental rights. Kindly come to page 10.
Swami and I'm Nagaraj.
Yes, kindly have the second case, my lord, K.S. Puttaswamy. It is in this background that the fundamental rights chapter has been interpreted. We may also refer to Nagaraj for the proposition that any true interpretation of fundamental rights must be expansive like the universe in which we live. The content of fundamental right keeps expanding to keep pace with human activity. So 26 has to be expanded, 25(2)(b has to be understood in restrictive fashion. Similarly, this Nagaraj I have quoted, kindly have para 20 of that. This principle of interpretation is particularly apposite to the interpretation of fundamental rights. It is fallacy to regard fundamental rights as a gift from the state to its citizens. Individuals possess basic human rights independently of any constitution by reason of the basic fact that they are members of the human race. These fundamental rights are important as they possess intrinsic value. Part 3 of the Constitution does not confer fundamental rights. It confirms their existence and gives them protection. Its purpose is to withdraw certain subjects from the area of political controversy to place them beyond the reach of majorities and officials, and to establish them as legal principles to be applied by courts. Every right has a content, every foundational value is put in part 3 as fundamental rights, as it has intrinsic value. The converse does not apply. A right becomes a fundamental right because it has a foundational value. Apart from the principles, one has to see the structure of the article in which fundamental value is incorporated. Fundamental right is a limitation on the power of the state. A constitution, and in particular that of it which protects and which entrenches fundamental rights and freedoms to which all persons in the state are entitled to, is to be given a generous and purposive construction. In Sakal newspaper, this court held that while considering the nature and content of human rights, fundamental rights, the court must not be too astute to interpret the language in a literal sense so as to whittle them down. The court must interpret the Constitution in a manner which would enable the citizens to enjoy the rights guaranteed by it in the fullest measure. So therefore, my lords, construe 26 in an expansive manner, construe 25 to be in a restricted manner, keeping in mind the context of the entirety of 25, 26, 27, and 28. All 4 articles under the caption of right to freedom of religion. And there is a double emphasis, brothers, right to freedom. Right itself is freedom, right to freedom of religion. So it's a double emphasis, brother, on this right to freedom of religion. It is in this context, kindly also now examine supposing 25 to be held to be applicable to 26, and state could make a law under this. 2 questions will arise, my lord. One has already been answered, that reform means social reform. It can't mean religious reform. But more important is this expression, throwing open of Hindu religious institutions of public character to all classes and sections of Hindus. To all classes and sections, the reason for classes and sections, one of the questions came from your lordships was this. Of course, under the Government of India 1935 Act, my lord, when this, there was the Pune Pact between Gandhiji and Dr. Ambedkar, whilst he was in jail and undertaking a fast unto death. There was an agreement between them that there will be reservation in services for the Dalits, but there will be no separate electorate. Now, based on that, Lord, the Government of India Act 1935 was passed, and in the schedules, Lord, there were rights given, and a scheduled caste order 1936 had been passed, which is at page 120 of this submission rules. At page 120, I have annexed it. There was a special feature of this. Why classes and sections? Please see the schedule. For every province, there was a separate schedule. So it was not uniform class. In some cases, particular section of one class is incorporated in one province, in other province it is not there. So there is a difference for each province. That is why, and this feature continues under our constitution, where the president not issues notification about the scheduled castes and scheduled tribes lists. Again, the same, every state wise, there is a list. That is 341, Article 341 and 342. So the submission is that this expression, classes and sections, on account of the peculiar history, on account of its connection with Article 17 and even Article 15(2), which in a different context talks about no discrimination against the Dalits. These classes and sections therefore means only the untouchables. I think Mr. Subramaniam has provided me a copy to your lordships about that book, Untouchables. Dr. Ambedkar had written that book, my lord, and interestingly, in this book, my lord, he has said that we are not a different race. We are all Hindus, and we have the same gotras as the upper caste has got. I'm not referring to this book. After this, my lord, then when there was this Pune Pact, he again wrote another book called What Congress Has Done to the Untouchables. Because he was put under so much pressure that Gandhiji will die if you don't concede this. And he was taken to the Jarawada jail, and for 6 days there was a debate between them before the agreement. So this classes and section is only referable to them. But more important, my lords, and this is also established by the fact that this is pre-qualified by throwing open. Why do they say throw open? Because it was closed for them. It is referring only to those classes and sections for whom the entry was barred. So the doors are being opened for them. So this expression throwing open to all classes and sections indicates that it is only referable to scheduled caste, scheduled tribes. Now, more vital aspect is, Lord, what is this Hindu religious institutions of a public character? What is it? What is sought to be opened up? Is it a temple or the institution itself? If this part of 25 2b is made applicable to 26, then the very institution of religious denomination would become liable to be thrown open. It's not limited to temple. It doesn't say that you throw open the denominational temple for worship. So submission is not that this Hindu religious institution, throwing open of Hindu religious institution is a matter of reform, where the whole institution can be opened up. But this won't apply to denomination, but they can't be opened up. They have to manage their own affairs under 26b. That's why the expression comes next is public character. What was said in Devaru was that since these classes, since religious denomination is a group of persons, it constitutes a section of public. Therefore, it is a public character. With respect, this is incorrect for the reason that public character is contemplated of the institution. Your Lordship will have to put the religious institution in focus and then determine, is it having a public character? When does it have a public character? Not some idea your Lordship will get from 27 and 28. Article 27 and Article 28. 27 says that nobody can be compelled to pay tax, the proceeds of which are specifically appropriated in payment of expenses for the promotion for maintenance of any particular religion or religious denomination. 28 says that no religious instruction shall be provided to any educational institution wholly maintained out of state funds. So if an institution, Hindu religious institution, is maintained out of the funds of the state, then only, Lord, it will have a public character. Otherwise, its character will remain that of a private religious denomination. It will not acquire public character. Please have Article 290A. This was inserted in 1956. A sum of 46,50,000 rupees shall be charged on and paid out of, my laws have this, 290 capital A. There are certain Devasam funds created. And the payment of money to them is charged on the consolidated fund. So the Hindu religious institution will acquire public character only in two situations. One, my lord, either my lord, they surrender their status as a public, as a religious denomination, and make it open, my lord, to everybody themselves. It should be opened up to generally to everyone, the institution. Then it will have cease to have a private character. Other or my lord, it is funded. That's why 28 says that wherever funds are being provided, no religious instruction, because then it acquires a public character.
So 26A also speaks of to establish and maintain institutions for religious and charitable purposes.
Yes.
Religious institutions, it says. And 25(2)
So
is
20
also saying
religious.
Hindu religious institutions
That's right, of public character.
of public character.
My lords, there can be a Hindu religious institution which is non-denominational. Supposing there is a Hindu religious institution, I set up a temple, my lords, and there's no denomination. Hanumanji's temple, my lords, is very popular, my lords, especially when exams are held. Everybody does go there. Kuch nahi to Hanumanji will see me through. So I opened a temple, so registered as a society, it's being managed by a, that will be covered by it. If the state wants, it can throw it open. The institution itself, they find that suddenly this is very popular temple, a lot of funds are coming, there is maladministration and so on, they may provide anything.
It doesn't restrict to temple only.
No, that's what I submitted. It
Religious
doesn't.
institutions can be temple and other institutions.
And management also. Institution, opening up the institution means you throw open the management also. That's a big danger of applying this particular part of 25(2)(b) to 26. The moment you apply, then the state becomes competent to throw open the religious denomination itself.
Doesn't speak about denomination at all. It only speaks, as my sister has said, it's about Hindu religious institutions. There's an objective behind this. It's only a place of worship or anything like that, where you restrict the entry, it can say, it says. It
doesn't-
Chief is also said that subject.
With
up to
respect,
17.
with respect, it
You can't
doesn't.
just take it to a very strange proposal.
All classes and sections means it is not dealing with management of those institutions. It is basically entry,
So
not management.
that is a big danger. Hindu religious opened up, throw open the institution.
Yes, for entry for all
But
worshippers.
Not in management, not in
In
administration.
management.
Now, kindly see, Lords, the problem which your lordships have in mind, which may arise if this submission is accepted, is then twofold. One, how do you bring in the Dalits? How do you allow other denominations to worship in that temple? These are the two problems for us. Article 17 takes care of, my lord, the Dalits. Morality takes care of Dalits. A law made which was challenged in the case of Devaru could have been upheld. And in that case, the judges also invoked 17. 17 read with subject to morality in 26 itself permits the Dalits to come in.
That was also Public Entry Act, Madras Act.
Yes, so it could have been upheld simply.
Of all persons in.
We don't need 25 to be last part. That could have been upheld simply by Article 17 read with morality. Because the right of denomination is subject to morality, law is upheld, valid, can be done. There's no need to bring in this last part.
It's right to be claimed.
Now,
We don't know on 25(1).
now let's talk about the other denominations.
There was a problem, therefore they took note of it.
Yes.
Now,
See, the evil was there. What was the evil practice? or malpractice, what you say, social evil, that they were not permitted to entry.
I understand. Yes.
Therefore, the Madras Act came. And at the Madras Act, when applicable, they said you have to open up the temple to all persons.
Absolutely, I'm totally in favor of that. I'm not against it. All I'm saying is that that law is perfectly valid and supportable by Article 17 read with morality in sub 26 itself.
So it is made having regard to the object.
But to draw,
22B.
there's no need to draw support from 25 to B. That's all I'm saying. I'm not saying that that law was invalid. The judgment is correct in conclusion. The law is rightly held valid. And speaking for myself, I fully support it. But the reasoning part only, I'm saying that it could have been easily upheld by simply saying Article 17 read with subject to morality is valid. 25 2B is a different altogether. Why are they saying Hindu religious institution? They are not saying religious denomination. Therefore, certainly Hindu religious institution is a wider expression. It could be denominational, it could be non-denominational, both. But it must have a public character. There has to be a conscious application of mind that you are throwing open the institution itself. It's a much larger power. And that larger power is, if a law is...
You have to understand, we can't take it that level. You can just say providing for social welfare and reform. And then, or throwing out the religious institution of a public character. So you have to see it's not an extreme case. It is not everything, every other case they want to say
No,
power.
well, there's no need. Please consider this. Even
we are not talking. It is there in the constitution. We have to just find out what is the objective behind it. Whether need it or need is there or not, it's not our job to go into it.
No, I'm not saying that. I'm saying it's not applicable in terms on a plain construction. That's my argument. Your Lordship may consider that part only as
contrary to what Mr. Gopal Subramaniam submitted, which again we also asked him. You can say probably now, unless it comes within the parameter of public character, it will not come. You can say, my institution will not come under the definition of public character, therefore will not do. As your example you have given, I can have a temple of my own. It is for 3 or 4 members of my family or my relations. Therefore, why should I allow somebody else?
No, I'm saying a religious denomination is a closed set which is disciplined in nature. Teacher taught religion, it goes like that. It's a closed set. It's not of a public character. So the moment I'm a religious denomination, I fit in under 26 and it's not of a public character unless and until I'm funded. Like in 298, I'm getting fund, or under some law, I'm getting funds.
Narrow view. See, the Hindu society must unify. Not say we are on one denomination, they are another denomination.
I agree.
They cannot come to our temple, we cannot go to their temple. That cannot be the idea.
Absolutely no.
The denomination will suffer if they don't throw open the temple to others.
No, with great respect, supposing
Get the income.
supposing there is some scenario where one denomination is being prevented from worshipping in another, although normally they themselves don't go, but even if they are going, what then law will be sustained under reform? The law of if the state wants that the other denomination people should also be allowed, it can make a law of reform.
So if you are allowing, there's no need to have a law permitting allowing and all that, because this came in 1950. What was the position in 1950? The social evil of exclusion was there. Therefore, it was added as a throwing open of Hindu religious institutions of a public character to all classes and sections of Hindus is to ameliorate.
So that is correct.
Down.
That is
social
correct.
evil.
That is correct. The evil is social.
Mr. Trivedi, your argument is that 25 2B is essentially meant for opening the Hindu religious institutions for all sections and sector sections. Say replanting 17 here for the purpose of opening the Hindu institutions. But that provision 25(2)(b), probably you want to say will not have an impact or cannot be used as a tool to tinker with the right of the denomination to maintain the affairs of the denomination under 26(b).
26(b) and the administration under 26(d). Those rights have to be protected.
Yeah. Opening of the institution, simpliciter, entry, it will not affect the religious affairs of a
That he is
denomination.
agreeing, that he is acknowledging.
Yes.
His only problem
not at-
is about management and
Yes.
affairs.
Okay.
I have no problem with that at all, my lord. I am only saying that that law will be perfectly valid under 26 itself, because it is highly immoral to keep them out, particularly after Article 17 has been inserted. So
Yes.
that is enough. But to draw in that 26(b), my lord, in my respectful submission, now, my lords, in the context of constitutional morality, my lords, and essential services, I'm adopting, my lord, the submissions of the learned Solicitor General and Mr. Vaidyanathan. I don't have much to say about essential services except to re-emphasize that it can't be used even as a tool, which Mr. Subramaniam is saying. I differ with him, my lords. This is not available. It can't be, my lords. How do you? It is, you say that religion will have to be decided according to the tenets of the denomination. If that be so, one has to look at that and find out, Lord, what is the religion which is being practiced by that denomination. Now, to bring in essential services means to virtually rewrite 25(1) and 25 and 26(b) both, because then we are reading it as matters, essential matters of religion. The word essential has to be inserted. So the moment non-essential comes in, and one doesn't know, Lord, how will the court decide what is non-essential? For all I know, Lord, when a child is 3-year-old and when his grandmother, Lord, rings the bell in the domestic temple, Lord, then he runs for the prashadam. That is how he knows that this is a temple and this is God. So this is one thing which the previous councils did not specify in the range of religion, is the prasadam parted, what he gets back. So can that be said to be inessential, non-essential? Of course, one can do without it. So all the various things, offering of flowers, etc., one can simply go and bend in respect. That is enough. Other things are non-essential from the point of view of worship. But the freedom of religion, my lord, would certainly include that the believers decide for themselves how they want to worship, when they want to worship, what time, etc., everything. So it's a wide sweep. So please jettison this. Unlike not, this is my prayer to your lordship is to jettison this. Don't keep a tool. And we have seen not the slide which happened. One of the judgments says that unless, my lord, the practice, removal of that practice, my lord, destroys the religion, that is the test. Is it destroying the religion? So there's no end, my lord. This then tool will require a sub-tool for determining essential, non-essential.
I think that has been argued well.
Yes.
That this expression essential, which does not find mention in the constitution, as probably Mr. Dhawan explained it.
Yes,
well,
yes, I adopted. I'm only
I
only made this little.
raised this argument of essential, and maybe Mr. Sai Deepak has tried to say it in a different way. He says essential means essentially religious practices, not essential religion.
Please don't jettison one idea and bring in another similar kind of idea.
mostly
Leave
these
it to
are
the denomination to decide.
For a judicial fora, these are very difficult, if
Yeah.
not impossible, parameters to how to manage the affairs, that to declare a particular practice as essential, the other not non-essential.
Look,
A denomination which broadly follows a set of practice are all religious practices for them.
one more vital
Barring
aspect.
those three constitutional provision of the moral part, social order, those three are
That's
there.
right. But one vital part of religion is emotions. Religion, my lord, attracts emotions. People are attached to the particular religious denomination, the particular temple. They get attached to that emotion and they react, my lord, very strongly, my lord, if that emotion is hurt. So therefore, the courts, my lord, will have to be very slow with a soft, light touch judicial review. And when it comes to the testing the law, it should be harsher. But in restricting, it should be very, very slow, my lord. Unless there is some, my lord, intention, somebody is playing a fraud on the religion itself and creating something which is really not established by any evidence at all. But if the tenets are there and if the practice is proved, etc., for a long-standing practice, then court should refrain from, especially if it is not hurting anybody. One more aspect is not about this 25(2)(a) when it uses the expression secular activity associated with this. Kindly have, my lord, paragraph at page 66.
Yes. 89 or 90?
66. Paragraph 89.
89.
And the submission is this. That 25(2)(a) says the state can regulate the social, political, financial, and other secular activity associated with religion. It enables regulation. It doesn't mean, my lord, that these aspects are outside the scope of religion. And for this purpose, I wanted to place this before your lordships at page 67. Please see that para 91. Initially, this interim report, explanation 2, that said that the above rights shall not include any economic, financial, political. Initially, the framers wanted to exclude it from the scope of religion. 92, then kindly have 93. Even the interim report of the advisory committee on the subject of fundamental rights dated 30th April submitted by Sardar Patel to the Constituent Assembly had followed the above pattern, and a similar explanation too had been incorporated in the draft Article 13. This continued to be so in the clauses on fundamental rights as adopted by the Constituent Assembly on April-May 1947. A true copy of the document is enclosed. Please see next page paragraph. Explanation 2 remained the same. Kindly see explanation 2. Clause 20. Rights conferred by this subsection shall not include. Then para 95. The final draft constitution dated 3rd of November 1949 included the right to freedom of religion in Article 25-26. The above mentioned explanation 2 in the draft article had now been included as Article 25(2)(a). The revised form of Article 25 made significant changes and it now included economic, financial, political, or other secular activity which may be associated with religious practice within the scope of right to freedom of religion. The fact, not that now 25 changes, not its text, and it clearly shows, because unless this is already included in 25(1), where is the question of saying notwithstanding one, you regulate this aspect? a temple will have to be built up, my lord, on some property, some land. The practice, the professing, the propagation will require funds. So these are all economic activities which are associated with religion, without which, my lord, the religion can be squeezed. So maladministration one can understand, but to say that this is out of, this is another, my lord, reason why we should not adopt this essential services, essential protection, essential matters test. So this part is also, actually it is part of religion and, but can be regulated.
That's what, instead of excluding it,
Yes,
they enable the state to regulate.
regulated. So state will have to, supposing state makes a law saying, my lord, that we acquire the temple's land on which it is standing. Your lordship may well strike it down that this is disproportionate, excessive. It's not really meant to regulate. Oh, ठीक है. So on morality, my lords, I have only to say that if the same thing that even 19.2 and 19.4, please insert constitutional morality and see, my lord, that the whole fundamental right of 19.1A and C will be totally. Then the limited heads will be expanded. We can pick up morality, my lord, from preamble, we can pick it up from directive principles, and whenever we want, and then 19.1A speech expression goes for a toss.
15, Article 15, interplay of Article 15.
There is a, वो कौन सा है? TMA pi वाला.
138.
Kindly, my lords, have.
Page 93, you are probably raising a new point of Article 15. Interpolate.
Yes. My lords are referring to page.
Page 93,
Article 15.
point number 10. Probably that is the interplay of Article 15
15.
with 25 and 26. Probably you are first time now.
Yes, yes. To some extent, Mr. Gopal Shankaran had also, my lord, referred to it, and I have quoted at page 95 that Tajmul Hussain, my lord, who wanted places of worship to be inserted in 15.2. Because I will not recommend, my lord, this vertical and horizontal test kind of thing, because subject to other parts, what your lordships perhaps could adopt the test is, does 25-26 have any bearing with that other fundamental right? Because 15.1 is an injunction against state. 15.2 doesn't have worship. It was rejected by the note itself saying that if you allow this, then there'll be cross entries of one religion to another religion. So they did not insert it there. Now 15.1 talks of only, my lord, that expression has been interpreted in TMA pi. I have quoted, your lordship will just take note of it. The bold letter in. So most of the articles are injunctions against the state. They will have no bearing with 25-26. Only 17, 23 and 24 also is child labor. Maybe some denomination is having some mining areas or something, then this may be of relevance. But basically it is 17, 23, which directly, my lord, apply because they are crime. No fundamental right under 25 or 26 can include a commission of crime, my lord. Criminal law has to be outside that.
Just fair and reasonable laws.
Oh. And finally, my lord, this laws which the legislature will make, it will have to be subjected to the rigorous test of just, fair, reasonable, disproportionate, should not be excessive, etc. The VG Rao test, my lord, which is Justice Patanjali, Chief Justice Patanjali Shastri. I'm grateful, my lord.
Thank you, Mr.
Excuse me.
Yes.
Wait, please. But I have two copies. You know, made a very short note, you know, I emphasized what we have done. Yeah, sure. You just. You know, at the end of the 3-page note is an article, my lord, which I had written in a book, which, my lord, happens to be on this judgment. So large parts, my lord, I will take your lordship quickly, but my submissions are now in 3 pages. My larger note, my lord, is there. I am not bothering your lordship because of paucity of time. Your lordship may note on the first page, I am appearing, my lord, for an association which is recognized by His Holiness, the Sayyidna of the Dawood Bahuri Bohra faith, and is empowered to represent and act on behalf of the Dawoodi Bohras. Our written submissions, my lord, are otherwise to be found at volume so and so, which run into 60-70 pages. I am not bothering your lordship there currently. Now kindly tell me not to the next page. I go straight to the issues that your lordship have framed. I don't want to go, my lord, on general discourse because that will take too much time. The first issue framed by your lordship, my lord, on page 2 is the scope and ambit of the right to freedom of religion under Article 25. Now, my lord, just don't read this. The scope and content, my lord, is that 25(1) is the right. 25(1), my lord, is subject to a plethora of restrictions. 1, it is subject to public health, morality, public order. 2, it is subject to other parts of part 3. 3, it is also, my lord, subject to 25(2), that a law can be made which can abridge, my lord, 25(1). So 25(1) is the right of conscience, propagation, etc., but is hedged by several restrictions which I have placed, my lord, in paragraph 1. I am not reading it, but that is how it is. Now, my lord, paragraph 2, I want to say something, my lord, on this issue of morality. Public order and health, we know. Public order as opposed to law and order. Health, my lord, of a threshold of an epidemic. That's the threshold. Public order, health. So the threshold of morality, my lord, will have to be that threshold for which there is a legal proper, my lord, phrase, which is called, my lord, nocitor associis, item 2. And that is that morality, my lord, will have the same threshold which is, my lord, of its companions. What are the companions, my lord? Public health and, my lord, morality, public order. So morality used here is of that threshold. So the power of the state to make a law based on morality must pass that high threshold. Otherwise, my lord, the content of 25, my lord, will be emasculated. That, my lord, is the principle of construction for the company it keeps. Now, my lord, the next item 3, according to me, my lord, I have made, my lord, a respectful submission here, which probably, my lord, I don't know if others have said. In my submission, my lord, this morality is to be viewed with the lens of religion. Why? Moral for some may be immoral for some. Obligatory for some may be, my lord, not obligatory for some. So every religion, my lord, has its own morals, which have been there for thousands of years. Your lordships heard the example of Dr. Singhvi about Digambars, my lord, who don't wear clothes, Naga sadhus. Society has also accepted, my lord, that this is the reason for thousands of years. And, my lord, we don't shut our eyes and start, my lord, abhorring if you see, my lord, a holy man of the Digambars walking naked on the streets. That is, my lord, their acceptance of morality may not be of somebody else's. Take dietary habits, my lord. Hindus, my lord, by and large, my lord, will not eat beef. Muslims, by and large, will not eat pork. That is, my lord, that is how it has grown. Nobody is right, nobody is wrong. Nobody is right, nobody is wrong. There are, my lord, dietary controls. There are dress codes. In some temples, my lord, you have to go bare-chested. In gurdwaras, you must enter only, my lord, with a head covering. Somebody will say, what's the point? Why should you cover head if you go for 10 minutes? Why should you go bare-chested? Why should you go without leather? Because some temples don't allow leather at all. You take off your watch if it is leather, you take off a belt. So those are, my lord, aspects of morality which must vary from religion and, my lord, from subtext and denominations also. So to give a handle to the government to make a law on morality as is commonly understood will not be appropriate in the case of 25 or 26. So view it, my lord, from this angle. That's, my lord, what I have tried to say in paragraph 3. Now, my lord, 4 is constitutional morality. I have dealt, my lord, a small part. I submit, my lord, constitutional morality has no place in creating a restriction. Morality is a restriction in 25 and 26. The moment you add, my lord, constitutional morality, you are either expanding the concept of morality, which the Constitution did not do, or you are adding another restriction on constitutional morality. With great respect, my lord, I have seen the debates. Dr. Ambedkar used it very infrequently, very infrequently. Judgments, my lord, from Keshavananda, and mainly now in, my lord, Article 377, Manoj Narula, etc., a lot of emphasis is placed on constitutional morality. Actually, my lord, I have written my article, I'll show. What Dr. Ambedkar meant was constitutional morality would be the spirit of the Constitution, not a restriction. What would be the spirit, my lord? I have given an example. I am not reading. Article 356, my lord. Article 356 is the power to dismiss, my lord, a validly elected democratic government. We, my lord, a basic structure of our Constitution is democracy. So when you examine 356 and the power exercised under 356, you will keep the constitutional ethos in view that we are a democratic country. We don't dismiss, my lord, governments lightly. So their power may be there, but when you exercise that power, keep the spirit of the Constitution of democracy in your mind. That was meant by Dr. Ambedkar for constitutional morality. Apply the spirit of the Constitution. Never to create a restriction, my lord. Because the moment you create an additional restriction by constitutional morality, you are diluting the content of 25 and 26, which in any case is subject in 25 to so many restrictions. You're adding one more. So constitutional morality, my lord, with respect, has no place at all in our Constitution. Now, my lord, if your lordship turns to page 3 bottom, the second issue. The second issue is, my lord, interplay between the rights of persons under 25 and the rights of denominations under 26. Now, please mark here, my lord, the rights of persons are in 25(1), not 25(2). And I'm saying it for a specific reason. Namely, the reason being that the question framed by your lordships, my lord, is interplay of 25(1) and 26. 25(2), whether it's an inroad on 26 or not, is not a question framed. Am I clear or not? We have had a lot of discussion here going on. I will address it in 5 minutes. But basically, the question is only 25(1) vis-a-vis 26. It is not the interplay of 25(2) with 26. It is not there. Your lordship should not really answer that question.
So there is no statute under 25(2).
I am grateful. Yes. And that is not there. But, my lord, I have said as an alternate, I will tell you, lordship, my lord, what I feel. Now, I have said, my lord. Yeah.
But there is no, the line attachment is not there.
So, my lord, what is the interplay of the individual when he goes, my lord, to the denomination? What's the interplay? My lord, Justice Iyengar, my lord, has said clearly in the next page that if in your own house, my lord, you do what you like, but if you go, my lord, and mingle in a place of worship, my lord, of the denomination to which you belong, you will follow the rules and procedures, like Gurdwara, like, my lord, this, that, and the other. You can't go to a Gurdwara and say, how does it matter whether I wear a headscarf or no? No. You will follow those rules if you want to be a part of the mat or part, my lord, of the denomination. Follow the rules. It is akin, my lord, to a society, to a club, to bar council, to have some orderliness, my lord. Every lawyer must follow the rules of bar council. Every member of a club has to follow those rules. Every, my lord, individual, when he goes to a mat and mingles with others, he has to follow those rules. Justice Iyengar used the phrase, it is necessary, my lord, for the denomination to keep the flock together. Can't be disruptive or schematic, the phrase used by him. How do you keep the flock together? Some amount of discipline. It has to be there. That, my lord, is on the next page. That is how the individual vis-a-vis the mat, my lord, will have to be placed. In your own place, house, you do what you like. If you don't like the mat, you can form your own religion. But if you like the mat or the denomination and you want to go there, please follow those rules. And some amount of disciplining is required, just as you can be chucked out, my lord, by a bar council or by a club or by an association. Even the mat, my lord, can throw you out if you are disruptive, etc. Kindly see, my lord, the words of Justice Iyengar in the Sayyidna case on the next page. Holds that a religious denomination possesses the right of enforcing discipline for maintenance of integrity of community. In the ultimate analysis, the binding force which holds a religious community and imparts it to a unity which makes a denomination a common faith, belief, and a belief in common creed, doctrine, dogma. The power of excommunication is vested in him for purposes of enforcing discipline and keep the denomination together as an entity. So that's how, my lord, the individual will have to fall in line when you go, my lord, to a mat or to an institution or to a club or to a society. That's how the interplay is. Now we come, my lord, to item number 6. This is, my lord, which is the most troublesome. Here comes Devaru. Now, my lord, see this. Your lordship's question. Whether the rights of a religious denomination under 26 are subject to other provisions of part 3 apart from public order, morality, health. Public order, morality, health, of course, are there. My lord, it is my submission that 26 does not admit of any other restriction except the opening, my lord, public health, morality, and public order. It does not. If you import, my lord, the restriction of 25(2)(b) into 26, as Devaru has done, go to Devaru for a minute. You are adding a restriction to the right of 26, which the Constitution did not restrict. By no process of interpretation can a restriction placed in Article A be a restriction in Article B. 26, the Constitution makers were aware when they framed 25, they framed it subject to this. But when they came to 26, they kept only the opening restrictions. Otherwise, they could have put it in 26 also. You could have said in 26, 26 subject to public health, morality, etc., and to something which was made and made in 25(2)(b). They didn't say that. Now see one more thing. So many articles are subject to so many restrictions. Article 19, 21, you can be deprived, my lord, of your life subject to procedure established by law. Article 22, 23, they use the same phrase. Nothing in this article. Have a look at the Constitution. Yeah. Just see this, my lord. The same thing occurs in 25, till 25. Very important. So, a simple manner of construction, my lord, would be that wherever there is a restriction, it is so stated. My lord, kindly turn to 19, your lordship has seen many times. I will not read 19. After 19, my lord, kindly turn, my lord, to 21. 21 is, the restriction is procedure established by law. Then your lordship will get to 23. See, 23 too. Nothing in this article. So again, my lord, a restriction. Now 25. Nothing in this article. That is 25 too. Now turn to 26, my lord. It is conspicuously missing, which was there in 19, 21, 23, 25, conspicuously missing. It admits, my lord, only on the first phrase, subject to this, and this. That's all. Therefore, there is no manner, my lord, on a pure construction of clear, unambiguous words that 26 can have a restriction of any sort except, my lord, the opening line. And there is no way that you will read 25 to B as a restriction on the right of 26. That is, my lord, a simple construction. But problem has arisen, my lord, because of Devaru. My lord, in Devaru, as the Chief Justice said, my lord, Devaru was a case, my lord, where temples, my lord, in prior to independent India, in the state of Mysore, then Mysore, did not allow, my lord, the lower class people to come to the temple. So a suit was instituted under Section 92 to frame a scheme and all that. Then came the constitution. Plaint was again amended. Question arose, my lord, whether the denomination would still have a right to stop those people who were otherwise treated as untouchables. So when Devaru, my lord, was decided, the opening, my lord, paragraph of Devaru is this interplay. And the entire judgment of Devaru is based, my lord, essentially on Article 17. It is based only on 17, which I'll show. So if it is based on 17 and throwing open the institutions, my lord, throwing open, allowing people to go in. So Devaru said that because of 17, you have to throw open. That's 25 2B. When you throw open, in some unintended manner, you are touching the rights of the denomination under 26. Because in 26, my lord, as it then stood, I mean, 50, 60 years ago, you could stop a group from coming. So Devaru said, by virtue of 17 and 25 to be, when you allow them to come in, with the guiding light being, you know, untouchability to be removed, you are actually touching upon the rights of the institution under 26. And therefore, they have held, my lord, and I say very, very broadly, and that, my lord, is not correct, to say that 26 is subject to 25 to B. Kindly now see that. That I submit is too broad and requires a correction.
Otherwise, they would have had to strike down the law. They did not strike down the law.
They said,
They said the law is applicable to that temple.
correct,
Therefore, you have to allow everybody to enter.
correct. But in that process, my lord, they said that 26 will be curtailed by 25 to B. That, my lord, is not correct.
Case, you have to harmonize it.
So, my lord, the harmonization, my lord, here would mean that you are creating a restriction in a compartment of 26 which doesn't exist in the constitution. My lord, have a look at what I have written here. Kindly come to item number 6. See, my lord, 1. The question in Devaru was posed in para 1 of Venkatramai IRJ, whether the right of a religious denomination to manage its affairs in matters of religion guaranteed under 26 is subject and can be controlled by a law. That is a conflict. By a law under 25 to be throwing open a Hindu temple to all classes. The question was answered by stating that to remove the taboo of untouchability as per 17, it was necessary to make a law to throw open the doors. The proposition is held in Devaru that rights under 26 will be subject to laws made under 25. Namely, this is the actual finding, my lord. We must accordingly hold that 26 must be read subject to 25 to be at, my lord, page so and so of the report is too broad a proposition. That's my submission. The case had nothing to do Lord, what the Chief Justice remarked 1 minute ago. The case had nothing to do with the issue of social reform and welfare, but related only to the interplay of 17 and the latter part of 25(2)(b). Special emphasis was placed on 17 relating to the taboo of untouchability. This was tied up with the latter part of 25 for granting access to general public, which was denied. The case does not deal with the first part of 25(b). The case is therefore confined to its own facts, the predominant feature being untouchability. Now, my lord, these three arguments I have made, kindly look at this. Firstly, it is submitted no specific issue has been framed by this court and a projected clash between laws framed under 25 and the right of a denomination. Not what I said 2 minutes ago. Second, the restriction to be created by law based on social reform should be treated as one only on the rights of 25(1) and not transcend into 26. Lastly, if it is held that laws under 25(2)(b) can create a restriction, which I don't agree to, then the threshold should be of a very high standard, like removal of untouchability, ban on child marriage or infanticide. So these arguments are in seriatim, my lord. Won't apply? If it applies, then applied in this case. Now, my lord, see what happened in Sayyadna. The Attorney General advances submission number 3, saying that even on the basis that civil consequences of excommunication are a matter of religion, still a measure of social reform, and the legislation would be saved. That is the legislation, my lord, which prohibited excommunication. The legislation would be saved. The legislation was challenged, my lord, in their case. Iyengar repelled. In my view, by the phrase laws providing for social welfare and reform, it was not intended to enable the legislator to reform a religion out of existence. 25(2)(a), having provided for legislation dealing with economic, financial, political, secular activities may be associated. The succeeding clause proceeds to deal with activities of religious groups, and these are also must be those associated with religion, just as the activities referred to in Article 25(2) are obviously not of essence of religion. Similarly, the saving in Article 25(b) is not intended to cover the basic essentials of the creed of religion protected by 25(1). Thus, 26 is not an island outside the bounds of state regulation. Undoubtedly, the state can make a regulation that religious denominations, that is freedom to manage affairs only on the ground of public order, morality and health, as stated in the opening chapter. The last point, my lord, is on locus. My lord, I submit in locus, a non-adherent will have no right to challenge, my lord, a religious practice. He can do it by a suit, etc., can't be a writ petition. And I submit, my lord, the judgment of Justice Malhotra in Sabrimala on locus, which is contrary to the 4 judges, because a lawyer, my lord, who challenged it. Justice Malhotra said, no, you can't be allowed to challenge. You are, my lord, a bystander. How are you challenging this? So second part, my lord, is this book, my lord, which I have. Only one portion I want to show, my lord. This is the critique I had written, my lord, more than a year ago. If your lordship just turn to it. My lord, the second page of that critique is about Sabrimala and Lord Ayappa. I am not bothering lordship with that. How it was formed, who was Lord Ayappa, how it happened, etc. Kindly, my lord, leave all that. If your lordship comes to, my lord, page 261 of that article on the top, at the foot, my lord, is the PIL issue. I have mentioned, if my lord sees that.
On the issue of maintainability.
Yes, I said that there itself, that you should not allow, my lord, people to, my lord, come to the court. They are interlopers, should not become. The next part is 265, at page 265. My lord, in this, I have discussed, my lord, the issues relating to constitutional morality, that constitutional morality has no place, etc. Then, my lord, page 271 deals with essential practices. This is actually, my lord, as they say, lordship knows, your lordship has said, don't enter a political thicket in cases. I submit, don't enter into a religious thicket to decide what is the essential practice. My lord, if people are debating, my lord, priests are debating, Maulvis are debating, what is or what is not an essential practice, very difficult for a court to get involved in it. And the constitution does not use the phrase essential, my lord. It uses religious affairs, religious this, religious that, but not, my lord, essential religious at all. Then, my lord, Essential practice, your lordship will get at 276. All that is here. And we'll at 279. I have said, my lord, that Justice Malhotra's dissenting view is the correct view. Then, my lord, I have given my conclusions. And the last, my lord, at 281, last para, is not supposed to be cheeky, my lord. If your lordship sees the last para, it is not supposed to be cheeky, but I have only said, my lord, that if one has shorter judgments, they are more accessible. And I have given, my lord,
Where are you reading?
there were 2 or 3 cases. The last para of that, my lord, that critique, last page.
As a general conclusion.
My lord, if I may tell you, lordship, my lord, your lordships are aware. If you see, my lord, judgments like Khwaja Nazir Ahmad to do a particular thing in a particular manner, or, my lord, that judgment on conspiracy, they also serve who stand in wait. One line. Still the law, my lord, those judgments are 3 or 4 pages each. On Hindu law, Hanuman Prasad versus Musammat Babui, 3-4 cases. They're all 3-4 pages, my lord. But you still follow them.
They were all argued for 2 days only.
So, my lord, I humbly submit, my lord, I didn't want to be cheeky, but since it was an article, my lord, I wrote that.
Oh, the Privy Council.
Your lordship.
Sir, okay, no problem. That practice also being followed now also. Now, most of the lawyers, they only read live law and bar and bench only. To understand the salient feature, what are the issues decided. Rightly so.
That's my submission.
Yeah, please.
I'm grateful.
Thank you, sir.
I appear for the Saidna, my lords, the head of the Dawoodi Bohra community.
Your lordship may hear Buthraj tomorrow morning, my lord, he will be waiting for it.
My lords, and how we've come here is that the original judgment of your lordships in 1962 of 5 judges in the case where that issue was challenged of the Maharashtra legislation. Then in 1986, my lords, came a writ petition which challenges a decision of the Constitution Bench. In that writ petition, my lords, first the 7 judges, which we objected to, then a 5 judges bench was constituted. And that 5 judges bench by a reference order sent that writ petition before your lordships, holding that specially issue number 3 and 4 have a direct bearing on the findings therein, because balancing of rights under Article 21 and other provisions was not considered, and whether morality and constitutional morality overlapped or whether they don't overlap. That is the reason, my lords, we are before your lordships. I have prepared my written submission, my lords. I'll stick very briefly. Can you just hand over the copies? Mr. Good Master, can I just, are there 9 copies?
9, those are 9. Those are black copies.
9 copies.
I am to wait.
Yes, of course. Of course. Just give it.
The notice matter is.
Maybe, let's see. On page 9, my lords. Nine.
Mr. Rohtgi was also representing the same.
Please, my lords?
Mr. Rohtgi was also representing the same.
No, my lords, they are the interveners in the sub-rem LA review petitions. I am a petitioner in the original 5 judges and respondent number 2 in the writ petition file, wherein a 5-judge bench was constituted referring it. So this is the
Same religious entity.
same religious entity. That's he's for a body of pleaders. I'm for the head of the community.
Right.
Yeah.
Different form.
Yes, yes, yes.
So, Mr. Kaul, the basic issue will be whether excommunication, banning of excommunication by a legislation under 25B was valid or not,
Right.
which in Saidna was held to be invalid. If we hold otherwise, we may hold Saidna view to be incorrect.
Right. So, my lords, my
So whether it's challenged by way of an Article 32 or not doesn't really become very relevant. It would be relevant whether our interpretation of 25(2)B in relation to 26B would entitle the validity of the legislation.
So my lords are right. That is why the reference order said, and when it was referred, that your lordships have framed these questions.
Right.
Your lordships are not deciding on the individual merits.
Right.
But what was said in the reference order was that two of these questions,
3 and 4. 3
3 and 4, if not 1 and 2 as well,
1
because
and
I
2.
briefly address on 1
Correct,
and 2,
1 and 2.
do have a bearing. And that is why on that I'm starting with issue number 3, my lords.
You are the writ petitioner.
The original writ petitioner, where the 5 judges decision came in 1962,
What was your challenge in the writ petition?
to the order of the Maharashtra government of the act banning any form of excommunication. The Maharashtra Act.
Prevention of excommunication.
Banning any
The Ma-
form.
Yes,
Excommunication.
Huh.
yes.
So in that, in the previous case, what was it in Sayadna? There
See,
also
my lords,
it was-
that's the Sadhana case, my lords. Yes.
No, there's already a judgment, no? Where
So the judgment was in the petition which we had filed challenging the Maharashtra Act.
No, the earlier.
Yes, the earlier, the 1962 judgment.
Yes.
Then in 1986, a writ came to be filed under 32 that consider a 5 judges decision. So that issue, whether a writ petition at all was maintainable is another issue. But under that writ petition, first a bench of 7 judges was constituted. Then we objected that without a 5 judges bench, disagreeing with another 5 judges bench, how can a 7 judges bench be constituted? So a 5 judges bench was constituted. That 5 judges bench, after going through the issue, said that some issues need to be considered because they may have a bearing on our matter, and by then your lordships had framed the questions in the Sabrimala matter, and we were directed to be tagged with this matter because issue 3 and 4 would have a direct bearing on our petition and the issues. So, my lords, the submission for your lordship's kind consideration under issue number 3, and then I will address the issue of Devaru is, my lords, it's important. 2 lines which have been missed out except for Mr. Dhawan or Dr. Dhawan referring to it at some stage. I'll just point that out. My lords, Devaru Act.
One second, let us have this clear. So excommunication was held to be valid by this court.
Yes.
Then after the judgment, what happened?
A writ petition came to be filed by some persons saying that the decision of the 5 judges was wrong. It needs to be revisited and reconsidered.
How is that writ petition maintainable?
That has been our argument right through. That's one. B, nonetheless, in that a 7 judges bench was constituted. We objected, how can a directly 7 judge bench be constituted? Then a 5 judge bench was constituted, and the 5 judge bench then referred us to your lordships in these review petitions saying that some issues were possibly not considered in that matter concerning part 3 rights versus 26 and 25. Morality, does it include constitutional morality or not? And thus is how we land up before your lordships in this
The
matter.
principle of res judicata not apply.
I
Once again, go into the correction. of the
I
judgment.
completely agree. But my lords, I am here because I've been sent here. I am here because your lords.
The question of
We are
practice.
the respondents there, my lords.
Correct, they are on the question of practice.
Absolutely right, my lords. We've been saying so right through. That if this is how a 5 judges bench decision will be challenged by by a writ petition under Article 32.
Recent case, we have dismissed it with a cost of 1 lakh.
Yes.
A 5 judges, Pramati was challenged in an Article 32 petition.
Yes.
Pramati, state of Rajasthan.
Yes.
It was
Yes.
challenged by one of the private parties under Article 32. We've dismissed it with a cost of 1 lakh. And we did not recall that order.
Well, in fact,
No, there's such a practice cannot.
yes, in fact, my lord, the
There's no
justice
finality then.
will recollect in the AMU cases also, one of the issues that arisen, my lords, that there is a procedure in which reference takes place to a larger bench. It just can't be that after 5 judges have decided, someone 20 years later decides to file a writ petition directly. And then that writ petition.
Don't be announced. Is it- Supreme Court.
Well, that has in any case been our fundamental submission.
That Pramati is referred now by Justice Dutta and Justice Lamont for larger bench because it excludes minority from having to give party.
But you mention, no, I'll give you the mic. Do that.
Who are the writ petitioners? Who are the writ petitioners in? Who are the writ petitioners? No, we are not on Pramati, we are on this case. Who are the writ petitioners?
I am appearing for the writ petitioners, my lords. I'll argue all this before your lordship. I'll argue. And I'll argue my case, but your lordship.
There the judges themselves referred 10 questions.
Lordship, please.
There was no writ petition filed.
With respect,
Vital difference.
I'll satisfy your lordships. If your lordships are going into an
Allow
individual case.
on filing like this and challenge judgment. There will be no finality. Until the 2 judges questioned 5 judges and raised 10 questions, the matter was referred to 7 judges. In a 5:2, the majority held that the 2 judges were correct and set aside the 5 judgment. That is different from this, where parties are permitted to just go on challenging. Where is the end? What is the status of the other earlier judgment in Syed now then? It has no finality then. We are on practice rather than on law now. No, we are on practice in Supreme Court.
Law. If this individual petition is to be gone into, I'm going to satisfy my lords. I am going to satisfy my lords.
This is serious.
Now that
This
this
is serious.
will be one of the issue
Yes.
that we will not with reference to or in the context of one individual matter.
Lordship, please.
But as a general principle of law, we would like to examine whether the court in exercise of 32 or 226 is in a position and competent to revisit a judgment by assuming a power of review or recall or.
I'll address my lords fully and comprehensively on this.
We will like to determine this question also.
In my turn, I will address it. In my turn, I will.
Simple answer is there is no data on question of law. Data facet ex albo nigrum ex no, there is no Data. Data is only on facts. Data facet ex albo nigrum ex nigro albo ex recto
We are not able to hear you anything.
Nowadays closed.
I will give another.